you can be given benefits. Please show me.
My lord, my school.
If there is a notification, I could have understood you have a legitimate expectation, you have a case, you have a legal right.
Yes, my lord.
Where is your legal right, Mr. Sharma?
My lord, my legal right was manufactured by the government 15 years
No,
ago.
no.
My lord, I had my rights.
Yes, where is your stand in your affidavit? Mr. Sharma, you can point out where is the which paragraph?
My lord, paragraph number 9, my lord, of the affidavit in opposition filed by the respondent number 4.
Yes.
They've stated the same, taken the same stand, my lord.
Yes.
Now, your lordship will permit me to place 3 orders of this honorable court, which are part of the records, my lord.
Yes, please.
Page 35. Page
Just 1 second.
Yes,
Let me
yes.
complete this.
Yes.
Read para 11 as well.
Yes, my lord.
Mr. Talukdar, in the meantime, you please find out if I'm not wrong, a division bench judgment is also there recently.
My lord.
Perhaps court 2.
My lord.
Yes.
That as regards the averments made in paragraph 14 of the writ petition, the deponent states that the office of the deponent issued the order under memo number so and so, dated 2019, in compliance of the Honorable High Court's order dated 29/10/2018, passed in WPC number 6742/2018, on the claim of the petitioner to give benefit of provincialization of services from the year 1991. That is from the year recognition of the school instead of 2013. Your lordship sees that the schools were recognized in 1991, madam.
No, on the claim of the petitioner to
For
give
consequential
benefit,
service, yes, madam.
benefit of provincialization of service from the year 1991,
Yes,
that
ma'am.
is from the year recognition of their school instead of 2013. Now, the school was recognized in 1991.
Yes, my lord. They were similarly situated, my lord. And the
No,
the-
one
the-
second,
yes,
one
yes,
second.
yes.
What do you mean by recognized? So, but the school was not done. The provincialization did not take effect. Did not take. Did not come in.
Did not come in.
They waited for so many years.
Yes, ma'am. There were administrative
Lapses.
that is my submission subject to what my senior friend will submit. In fact, there were 1,600 schools in the state of Assam, under which my school.
Go slow, go slow.
Yes,
I'm
sorry.
hearing you, Mr. Sharma.
So there's
1991, that recognition.
Yes, madam.
From where? Which page you show? Which is the page?
My lord, the provincialization of the school.
Recognition, 1991.
No, ma, that is our submission, my lord.
Oh, that's your
That is
submission.
my submission. That is also validated, my lord, because our entire petition
Just what do you have to say to this? You're not even answering to this.
is based on violation of equity, my lord.
They are saying that you have given recognition to this school in 1991, and yet you waited for so long and finally provincialized in 2013, for which they are suffering. Otherwise, they would have got the benefits of provincialization
Yes, madam.
way back in 1991, but because of your lapses. Where have you explained all this? I don't see anything. Your paragraphs are very short. You are only saying that they are not entitled.
My lord, provincialization under 2011.
Yes, but their allegations have to be answered.
My
If
lord.
you do not answer, who will answer? You are the state. Are you not supposed to answer the allegations, or are we supposed to then we will construe that these allegations have been admitted because you are not even denying it? Yes, Mr. Talukdar, I think a better affidavit should have seen the What kind of an affidavit is this?
It's only, my lord,
Who's filed this affidavit?
My lord, paragraph number 4.2
Yes, paragraph 4.2.
and 4.3, my lord. The government of Assam.
Where is your response to all these paragraphs? Huh? In paragraph 4.2,
2.3, my lord.
your reply is matters of record.
My lord, the last page,
Huh?
last sentence.
4.3,
Last
matters
sentence.
of record.
Last sentence, sir. The last sentence in page 8, madam. The said notification dated 5/10/1993 came into force with immediate effect and also.
I've seen.
Yes, yes, madam.
Yes. Yes, Mr. Talukdar.
my lord. There was reply not given, my lord, only just one.
Yes.
They have
And,
stated that
looking into the affidavit, you will get no help. I'm telling you, I have
I
seen
don't-
it. You will not find any help in that affidavit. Nothing has been answered. Do you have the records? That also you will not have. How do this court dispose of matters then? Explanations are not there in your state affidavits. Records are not there when matters are listed for admission.
So I pray for.
Yes, I knew you would be making a prayer. That is why I am saying that how do the court dispose of matters? I have invested sufficient time in this matter today, judicial time. I can see a lot many lawyers are waiting for their turn. Because of not filing affidavits clearly, matters have to be adjourned. You should have clarified the main issues. These are the issues.
Violation, my lord. That is what I'm saying. There's no other ground.
Yes, what is that you have got?
One judgment, my lord.
Judgment will come later.
My lord.
What anyway? What is that judgment?
That passed by the coordinate plans, my lord. WPC.
No, forget. Why are you referring to all that?
Benefit of the petitioner is not yet, my lord.
Huh?
Paragraph 8, kindly peruse that. Paragraph 8. Para 8, man.
Yes, this is exactly what I was saying, Mr. Sharma. A perusal of the above provision of the 2011 Act shows that on provincialization of services of the teachers, their past service rendered in the venture schools cannot be counted for any purpose whatsoever. All such employees are to get the same pay and allowances as if they are fresh appointed. I understand you want to say that this is 2011 not applicable because you could have
Yes, ma'am.
been provincialized
There's no dispute with that
in
provision.
1991.
Ma'am.
Had after that recognition, they would have done their part.
ma'am.
Correct?
Yes, ma'am.
That is why you are saying that you have to clarify these positions, Mr. Talukdar.
Violation of
If you did
my
your-
lord.
Yes.
In fact, my lord,
Serious lapses on your part has been alleged in the writ petition and you're keeping quiet. Or you want this court to give a verdict. Huh, Mr. Talukdar, you're staring the bench will not help. You have to say something.
my lord, you ought to be kindly come to page 38 for a moment.
Page?
38. It's an admission on the part of the government.
Page 30.
8, Annexure 6. This is a communication from the government to the Director of Elementary Education, my lord. The writ petitions, which has been referred in the subject matter, my lord, the petitioners are a part of that association. If I may permit to read.
Yes.
Sir, in enclosing here with a copy of representation received from Sri Nogendra Sondra Bormon, General Secretary, All Assam ME/MEM Schools, recognized 1990-1991 School Teachers Association along with its enclosures and other relevant particulars of left out MEM schools and eight districts in Assam, which is self-explanatory. I'm directed to request you to furnish the detailed report along with the following information.
Where is this detailed report?
No report had come thereafter. My lord, reasons.
Yes,
for
what
that-
have you done after this?
Your
This
Lordship,
was given to the Director of Elementary Education. I think this affidavit is filed by the Director of Elementary Education. Yes.
that is the affidavit.
What have you done? Your affidavit is silent on
Silent.
Annexure 6. Yes, please take down. Heard Mr. M. Sharma. Learned Counsel for the petitioner also heard Mr. B. Talukdar, Learned Standing Counsel, Elementary.
My lord.
Elementary education. Stop. The short question involved in this petition is whether the petitioner is entitled to the benefits of provincialization.
Yes,
huh?
my lord.
Provincialization with effect from 1991,
Yes, ma'am.
when other similarly situated ME schools
Yes.
had been brought under the scheme of provincialization in terms of the policy guidelines laid down in notification dated 5/10/1993
Yes, ma'am.
instead of
2013, ma'am.
2013,
Yes, ma'am.
on which date the
The petitioner services
the petitioner's services
were provincialized, ma'am.
was provincialized. It is the specific case of the writ petitioner that, due to serious lapses on the part of the state government, despite the school having received recognition way back in 1991 for provincialization, the provincialization order was not
Benefit was
effected.
effective, ma'am.
Stop. It appears that Mr. M. Sharma so and so draws the attention of this court to the Annexure 6 enclosed to the writ petition, which reads as hereunder, quote unquote, page 38. It appears that in the affidavit in opposition filed by the respondent number 4, I, Director of Elementary Education, within bracket Department Assam, Kahilipara, there is no whisper as regards the steps taken pursuant to the letter dated 26/3/2004 issued by the Undersecretary to the Government of Assam, Education within bracket Planning Department, to the Office of the Director of Elementary Education, Assam, Kahilipara. Stop. It further appears that the affidavit is further silent as regards the claim of the petitioner on the basis of similarly situated
Yes, ma'am.
persons having been
Provincialized.
provincialized. Since there is no clear, since the matter could not be taken up for hearing for want of clear instructions, let a detailed affidavit be filed by the respondent number 4, clarifying the above issues and also responding to all the allegations leveled in the writ petition. Stop. Let the affidavit be filed by within yes, when 10 days. If 10 days of the time within so and so date, relist after 3 days of that date on such and such date.
Item number 19.
May I please, Your Lordship, I beg to mention item number 13, Lordship, maybe taken up two, Lordship. Lordship, extremely sorry.
Order has been passed.
Lordship,
Yes, next.
Lordship,
Order has been passed. Now, please
Lordship, senior,
do not waste the judicial time of this court. Next.
Item number 19.
May I please, Your Worship, my lord? But in this case, my lord, the government is supposed to file the affidavit. No affidavit has been filed. The matter relates to, my lord, in the event of my lord, in the event of amalgamation of two schools,
Hmm?
in the event of amalgamation of two schools, the LP and ME school in terms of the policy decision of the government,
Hmm.
whether the teacher working my lord LP school in the event of amalgamation are entitled to my lord get their seniority intact for the purpose of promotion to the post of my lord headmaster. This is the question involved, and ultimately my lord junior was accommodated, and that was suspended, and my lord BO was allowed to hold the charge of headmaster. Therefore, my lord, amalgamation policy, my lord, covered my claim. I am entitled to be considered for promotion, whether regular or my lord against ad hoc promotion. That was
Your claim is for promotion.
promotion. On the basis of my seniority,
You are an assistant teacher.
I am an assistant teacher working in LP school.
Respondent number 9 is senior to you or
Junior.
Huh? Junior.
And she was also not my lord, willing to hold the charge. Despite that fact, she was directed to hold the charge.
So you are challenging her promotion.
Right, my lord. And that was suspended. And now BO was allowed to hold the charge.
Now who has been allowed to hold?
BO, Block Elementary Education Office.
Respondent number?
Respondent number respondent number 8. No, respondent number 6. 6.
Charge.
Yes. Now they are proposing, my lord, to my lord hold the regular selection. Name was recommended. My name was not, my lord. Other teachers were recommended. I was not recommended. Therefore, my lord, whether I am entitled to get
Yes, who is appearing? Affidavits have been filed?
No, my lord.
no.
Why?
Instruction.
Why affidavit not filed?
Instruction.
There is an interim order.
Yes,
My lord.
Yes.
Instruction A to be received, my lord.
21 matter.
My lord.
How many more years you need for instructions? Mr. Talukdar? How many more years?
The communication from the department, my lord.
No, I'm not asking about communication and all that. I am only asking a very simple question. How many more years you need to obtain instruction? 21 matter.
My lord. Sorry, my lord.
All right. Last chance.
Last one.
Heard Mr. A.K. Purkasta, learned counsel for the petitioner. Also heard Mr. B. Talukdar, learned standing counsel for elementary school education. It appears that the affidavit in opposition on behalf of the elementary school education is yet to be filed. Mr. B. Talukdar with profuse apologies seeks a last opportunity to file the return. Prayer is allowed. It is needless to be clarified that in the event the affidavit in opposition is not filed by the next date of listing, the matter shall be taken up in accordance with law.
My lord. And interim order.
Interim order, if any, shall continue till the next date of listing.
Obliged.
Did you know? Released after 2 weeks. Mr. Talukdar, 2 weeks?
Time being item number 11.
Mahmood, Mr. Mahmood, it is you're agreeable to the mediation or you're not agreeable?
Yes.
Agreeable? Yes, Ms. Musar. It is Bhargavak agreeable will equate. Please give your appearances. A copy of the order will be given to you all. You will know the date of appearance before the mediate.
Obliged, sir.
Mr. Mahmood, next time you give chance to your juniors also. This is the only instruction she has to tell the court. This much you can always rely on your juniors. Otherwise, when will they learn?
Yes.
Yes, next.
Definitely. Item number 21.
Yes, Mr. Kashyap.
May it please your lordship. Lordship, this matter was reserved for judgment. However, it came up again. Lordship, we would like to go through the records that were there with the permission of this court. And if your lordships would kindly.
All right. But last time also, on 13/8 also on the same ground time was taken.
So I'm not aware of that.
Huh?
This
This
is-
court's order only.
In Lordship, I'm appearing for Mr. P.K. Tiwari, Senior Counsel. We have no objection per se, but however,
All
it will
right.
be taken.
Heard Mr. T. Kashyap, right? T. Kashyap, learned counsel appearing for the petitioner. Also heard Mr.
You, Pathak.
U. Pathak,
Appearing
learned
here.
counsel appearing for respondent numbers 2, 3, 4, and 17.
Yes, Lord.
Mr. Kashyap seeks a short accommodation to go through the records of the case, which is not objected by the other side. Relist when?
Well, on 23rd, my lord, October.
Pariba? On such and such date.
After wedding.
Hello, much okay.
Item number 22.
Lordship, kindly pass over the time.
Hmm?
Kindly pass over a matter for timing, Lordship.
Rejoinder filed or not?
Everything is filed.
What is this matter, Mr. Deka?
This is regarding an appointment in the Guwahati Refinery, my lord. Posts were advertised. He has not enclosed the relevant criteria. I mean, the relevant document pertaining to his eligibility, it was rejected. Yes.
Now he's challenging
he's
that.
challenging.
You will not enclose your particulars, rightly rejected.
Yes,
Huh?
it was genuine mistake.
Genuine
A
mistake.
Genuine mistake, Lordship.
How can the mistake be rectified now? You are seeking appointment. You should have been more vigilant and careful while you are submitting your applications.
Lordship, we
Where is the scope of making mistakes when you file applications for appointment?
Lordship, we uploaded the certificate, but the
Hmm.
endorsement part was not uploaded only. That is.
That cannot be condoned.
That is the most important thing. But the requirement is that he has to be qualified as a second class boiler operator, or he must have passed the apprenticeship, done the apprenticeship, and that apprenticeship is certified as equivalent to second class boiler. There is a procedure under the
Then
boiler rules.
where is you have a case?
Lordship,
Why do you want time? I can dispose it right away.
No, Lordship, my senior, he is in court number 16, Lordship. He's on
Okay,
late.
two then.
Lordship.
We'll try at two.
Lordship.
Mr. Deka at two?
Okay.
Yes, I think your senior has come.
Lordship, yes.
Yes,
Lordship, may take it up at 2 then.
but you are here.
Lordship,
You have come. We
I
can.
just came.
You came running. There's no problem. You take your seat after the next matter. Call it after the next matter.
Lordship,
Huh?
Lordship will take.
Oh, it's okay. It's okay. You want water?
No, no.
Yes. Take your time, Mr. Bora.
But this is a selection process initiated by advertisement for the post of junior assistant.
Hmm?
Number 4, page 28 is the
Page.
24 is the advertisement.
So this case is for appointment of
Appointment of
First
various
selection.
posts in the
selection,
refineries
right?
division.
Selection.
Selection
For
various posts, including junior assistant number 4,
junior
Engineering
assistant.
assistant.
Huh?
engineering assistant
Engineering is
number 4.
grade 4 PLU, power and utility.
Page 23.
Page 24, Lordship would see
Yes.
A for refineries division, A, Lordship would find the requirement of non-executive personnel.
Yes, for refinery division. Yes.
For refinery division, in the pay scale 25,000 and post code 201 to 208.
Hmm.
My postcode is, Lordship would find in the chart at 202.
Postcode.
Postcode is 202.
What does postcode means?
It's just a code to verify the post, identify the post.
Okay. Your postcode is
202, junior engineering assistant
202. Where do we get that?
at the
Yes,
bottom
yes,
of
yes.
the
Yes, yes,
page.
Yes.
So I am a scheduled tribe candidate.
Yes.
In ST column, there is one post.
Where do I find that? ST. Yes. One.
ST column, one post.
Yes.
So I was the only one selected.
ST Hills.
ST Plains, Lordship. I have annexed the ST certificate at page 20.
No. Okay. Sorry. Yes. ST. Yes.
Now, Lordship,
Yes.
at page 28 is the qualifications.
Page 28. Yes.
3 years diploma. 202 bottom of the page, Lordship. Qualification and work experience.
Yes.
3 years diploma in mechanical engineering or electrical engineering in electrical and Lordship gets it.
Yes. Yes.
Electronic engineering or metric or ITI fitter of minimum 2 years duration or BSc Maths Physics or industrial chemistry from recognized university along with that this is the point, Lordship.
Yes.
Boiler competency certificate with second class or national apprenticeship certificate in boiler attended under the Apprentice Act 1961 with due endorsement of equivalence to second class boiler attendant certificate of competency by the competent boiler authority of the state of refinery unit for which the candidate has applied.
Apart from this diploma in so and so, a certificate, boiler competency certificate with second class or national apprenticeship certificate in so and so under the so and so act with due endorsement of equivalence to second class boiler. So this is the certificate which is required.
Yes,
If I understood Mr. Deka, I think perhaps this is not, something is wrong with
Yes,
this,
yes,
right?
yes. Lordship,
Yes.
now at page 22 is the certificate.
Page?
22.
Yes.
Page 22 is the certificate.
National Apprenticeship Certificate.
This is the certificate.
given to
Lordship.
you.
Yes.
Your name, Mr. Okay. Yes,
Hemkantola.
yes.
Now date of issue 3/6/2022.
Where do I get that?
Last at the bottom
Yes.
left side.
Yes.
Now at the next page is the endorsement.
The certificate is made valid as an equivalence. Okay.
Here, Lordship, date is not given, but here date is not given. They have issued it.
Oh, there has no date.
There is no date.
Yes.
I may also submit that they are parties as respondent number 5 and 6. They have not filed affidavit.
5 and 6.
5 and 6.
Who the boiler attended examination?
Chairman boiler board, boiler attendant examination board,
Respondent number?
and 5 and 6. No,
5 and 6.
5 and 6.
But how come this does not has a date?
Lordship, therefore I pointed out they are the proper authority to rebut that.
But date as such is not required so
Not
much,
required, not
right,
required.
Mr. Deka?
In this case, he has not annexed this part.
Understood. But otherwise, date is not
Otherwise,
is of no consequence. I
the
don't
seal
think
is
so.
there, my lord. We are not.
I don't think that.
The authority is not disputing this.
No, the question now is that you have not
No,
given this.
That is the only issue.
The mandatory,
No.
your qualification parameter is a mandatory column, whatever is
Lordship,
there.
I'm
The
coming to-
credential, the certificates you have to enclose.
No, I'm coming to-
Now, by mistake, if you forgot, how can after the selection is over or what?
But there is, I
No,
think there is an
the
entry
post
motive.
is
Post
kept
is kept
vacant.
vacant.
But
Vacant.
selection is on.
Selection is on.
Others have.
Yes.
So how
No, it is
can
not-
we?
not
Because you forgot, now one post is also kept vacant for you.
Yes.
How can that be done?
No,
Mr.
Lordship,
Borja?
I'll come to the rejection part on the impugn order.
Yes, where?
And thereafter, Lordship, I'll just for the perusal of this court, Lordship, I'll just show the advertisements, important parts of the
Yes,
advertisement.
yes. You take your own time.
Page
Yes.
32, Lordship.
Page?
Page 32.
32.
Page 32, the chart.
Yes.
There are two parts, qualification and experience. For this post, experience is not required.
In 32.
Page 32, serial number 2 in the chart.
No further experience shall be required.
That is one logic. Now,
Now, 1 second. But what was this then? Post-wise qualification parameters. Qualification parameters and work experience criteria.
now
Now, this B says work experience criteria for refineries division
Not
required for postcode 201, 203, 2. But 202 is not there.
No, not there. I
No.
wanted to point out that work experience qualification is not required.
No, but that is only for 202.
202, mine is
The-
202.
So B does not relate to 202. Where is 202? It says, if you see the heading in B, please see the heading.
For my post, there is no experience criteria.
No,
No
one
further
second.
experience shall be required.
No, that, oh, here it's given post. Okay, 202, no further experience. All right.
Now,
And this
I was-
certificate is work experience. The
basically-
certificate is an experience
No,
certificate.
not really. It is a part of the qualification only.
No, qualification and experience
Apprentices.
criteria, isn't
Yes,
it?
yes, yes.
So,
Now at page 37, look. 36, the selection
this
methodology.
apprenticeship will not be in a qualification. It would be in,
It is a qualification.
it is a qualification.
Because if your lordship sees page 37,
Yes,
no, page 32,
yes.
for say junior engineering assistant grade 4 production, minimum 1 year of post qualification work experience. So you acquire the eligibility criteria, then you have to work somewhere. But for boiler operator, no further experience shall be required. He has done the apprenticeship, so work experience is not required.
Okay, anyway,
Anyways,
all right.
Lordship, at page 36, now the main part starts. The selection methodology. At the last part, J,
36.
36.
Yes. Yes.
The selection methodology will comprise of a computer-based test and a skill proficiency physical test. These are the two tests.
Yes.
Now, Lordship,
But selection methodology has any
yes,
relevance?
yes.
Yes.
Now, I was called for the
Selection.
CBT test. I gave the CBT test. I cleared the CBT test. At serial number 3, Lordship, at page 37, the cutoff marks is 40% for general and 35% for
ST.
ST.
Hmm.
I scored 62.
Hmm. Yes.
Now, Lordship would see, when I come for the CBT test at serial number 11 at page 38,
Yes.
the
Serial number?
candidates,
16.
11, Lordship,
11. Yes.
identity verification.
Yes.
The candidate called for CBT test shall be advised to produce certain documents for verification in original and to submit the attested photocopies thereof. At the time of the document verification, the such documents shall be listed in the call letter. If the identity of the candidature is in doubt, he is
Or
not,
she is not
not
able
able to produce the requisite qualification, or there is mismatch of information in the
So
document.
in your call
Sir,
letter, there is no mention of this apprenticeship certificate.
no, Lordship, they have verified before the CBT test, and they have allowed me to sit.
So
I now
they
clear.
did not ask for.
It is not asked for. Now I am coming to more, Lordship. Now they have physically verified.
One second. The candidates call for so and CBT test shall be advised to produce certain documents for verification in original and to submit so and so at the time of so and so. Such documents shall be listed in the call letter. If the identity of the candidate is in doubt, or she is not able to produce the requisite documents, or there is a mismatch of information, so and so will not be allowed to appear for document verification, and her candidate will be treated as cancelled. So if you have not produced it, then to your candidates will be treated as cancelled.
But I was
Never asked.
documents were verified, and I was allowed to sit in the CBT test.
Okay. Okay.
Now, Lordship would come to the online application part.
Yes.
First, Lordship would see at serial number 8, I missed this number.
Yes.
Serial number 8, very important.
Yes.
candidates must ensure to upload clear and legible self-attested scanned copy of documents, matriculation, higher secondary, class 8, ITI, diploma, BSc, caste certificate, PWBD certificate, EX, SM. Lordship, now here also the certificate is not there in the instruction to upload.
Experience, what is this? There must be one single upload file against each category of documents. For example, under experience criteria, upload candidate must scan all the certificates, letters he is claiming, process relevant work experience. Failure to comply with the aforementioned provisions of uploading documents shall render the candidate ineligible. This is what you are trying to. Yes, but one of these, na? Without any liability. Yes,
So
it is clear.
so in this, Lordship would see what I wanted to point out.
So those, that doesn't mean that qualification will be not read into this clause. It says candidate
Lordship,
must ensure to upload clear and legible
the certificate
of
to-
documents.
the certificate to be uploaded is mentioned here. Apprentice certificate is not there, Lordship. For my argument, I am submitting.
Okay, okay.
Now, Lordship,
But one is there, any other prescribed document,
Any other
and any other.
prescribed documents, yes, that is
That
there.
is there.
That is there. That is there. Now, Lordship, at page 42,
His Lordship is at
page
least
42,
page 42, 13, Roman
I
7.
am coming to
Everything is
it. I am coming to it. I am page 42. I am coming to it.
Yes.
Uh, at at page 42, serial number 13. After entry of all the details in the online application form and upload of the digital photograph, signature, good quality scanned copies of the prescribed size and formats as applicable of the following documents are to be uploaded to complete the application
Which
process.
part are you reading in
Page
42?
42, clause 13.
Yes.
There is one clause that goes against me here.
Yes.
After entry of all the details in the online application form and upload of the digital photograph and signature, good quality scanned copies of prescribed size and formats as applicable of the following documents are to be uploaded to complete the application process. Please go through the details on scanning of photograph, signature, and documents. Please note that the below mentioned documents are applicable and are to be scanned in separate scan file and for upload under the respective upload tabs. Now at serial number 7, for candidates applying for postcode 202,
Yes.
boiler competency certificate
Or national apprenticeship certificate.
attendant with due endorsement, this is a certificate.
So this is there.
This is there, Lordship. Now
Is this against you?
this is against me. Now at page 47, Lordship, this is my form.
But Mr. Bora, as you are taking me to the depth of the merit of the matter, it appears that you have no case.
Lordship, I am coming to it at page 47. At 47, Lordship will kindly have it. At last, Lordship will equitably consider.
Yes, yes, of course I'm considering, but I'm indicating that you'll have to try more hard now. Yes, 47.
47, Lordship.
Yes.
Lordship, this is my form. Are you candidate with boiler apprenticeship of 20 and having national apprentice certificate in boiler attendant under Apprenticeship Act with due endorsement? I mentioned as yes, Lordship.
But where is the certificate?
No, certificate here, Lordship.
Where is the certificate?
Certificate, Lordship, at page
No,
50.
Not in the writ petition. Before the appointing authorities, when you submitted your form, when you uploaded your credentials, did you upload it?
Lordship,
Did you upload it? Yes or no? At the time
that
of
mistake I committed.
Correct.
Oversight.
So, yes, in page 47 is no good unless and until you have uploaded.
Lordship, there is no
Hmm.
misrepresentation of any fact.
No, I'm not on misrepresentation. You see, nobody is alleging that you have misrepresented. I don't think that is their case. I don't think that is their case.
Just by
That-
oversight.
whatever be it, you see, Mr. Bora, these are serious issues, right? Because you are now seeking appointment. You have to be more vigilant and careful. Now, if certain documents are made compulsory, mandatory,
Yes.
then you have to be extra careful. You are being not vigilant. It is your fault.
Yes.
And this clause, where is this gone? That clause number
42
at
clause.
page 37. And any other prescribed documents, failure to comply with aforementioned provision of uploading documents shall render the candidate ineligible for selection process without any liability on the corporation in this regard.
Yes, Lordship, I'll show the rejection order also. What is the language in the rejection order?
But after this also they called you for the test.
Yes, they verified the physically
That
document.
test they had called. Where is
that-
that letter? Call letter?
Call letter, I just asked him in this morning. Here it is on record, it's not there, but I can file.
You
a
have a
petition.
copy of the call letter?
It's a wrong statement, my lord, that he was called in spite
So
of that.
there was no
No,
call.
my lord.
Ah,
Lordship will kindly consider when.
all right, all right. Yes.
Now, Lordship, would see page 50. Page 50, Lordship would see, do you have the boiler competency certificate again?
That's
Yes.
been yes.
Yes, page 50.
Your yes there. You see, Mr. Bora, you focus on the case, the defense which has already been on record, because they are not saying that you have misrepresented. That is not the case. Let's not waste judicial time on that. Yes, we've understood that you
yes.
have. We have understood that your intention was genuine. We've understood.
At page 58,
Now-
now is the impugn order.
Hmm.
Impugn order is at page 58.
Yes.
Total score, Lordship would find page 62. 62 total score out of 100.
62? There is no 62 in my file.
Page 58.
58.
Page 58.
Page 58, yes.
Total
Total score 62, yes.
62, Lordship. And remarks.
Yes.
Shortlisted for document verification
Submitted
and
does
no.
not have endorsement from so and so as equivalent to BCC second class.
That I have, Lordship.
So, Mr. Deca, one small query.
Yes.
In that certificate, where is that? Where that endorsement?
Page 22. 22 and 23 is the
If you-
endorsement.
Now, 22, 21, then 22. So, is it that 22 was available and 23 was not available?
yes.
That's your case, correct?
No, no.
22 is available, 23 is not available.
23 was not given. Now, in the petition, they have enclosed 23. That is your case,
Same
right?
certificate or PPT?
Yes, so
Uh,
this is what it says.
So-
Remarks, apprenticeship certificate submitted does not have
Does not
endorsement.
happen. It's
So-
not that the apprenticeship certificate not
It is-
submitted.
Correct.
Yes.
It says does not have endorsement from Boiler Authority of Assam, so and so.
That-
So
that-
this endorsement, which is as Annexure
My
4.
argument is, Lordship,
Hmm.
on that date, Lordship, on the day of advertisement and the day of selection, I possessed it. Based
But you
on-
have not enclosed it.
Yes, that.
And the one which you have given in the writ petition also does not bear a date. Also does
Lordship,
not bear a date. It
Lordship,
is not inspiring confidence also.
No, that 5 and 6 will explain, Lordship.
No,
They have,
why 5 and 6 will explain? The date should have been here.
Lordship, and moreover,
Where, which paragraph have you said? Which is that paragraph where you have discussed Annexure 4? Paragraph.
yes. Paragraph, Lordship, para 4, Lordship. That's why I made them party, so that
That's all right. Why should they be bothered? They are not, they have nothing, there is no relief claimed against them. They may not appear, Mr. Bora. Yes.
para 4.
Yes, where have you said,
And it is not a separate.
where have you stated on oath that you had this endorsement certificate from before?
Lordship,
Which paragraph?
that thing, Lordship, I read, Lordship.
Which paragraph?
It is not there, I suppose.
You have not stated.
Because in the affidavit also, it is not their allegation.
That is all right.
Only the date is not there, they mention, but it is not their allegation that I
And
did not possess it.
where have you said why that you have uploaded it by mistake? You have not.
Yes,
uploaded it.
many times I have.
Where? Which paragraph?
Yes, Lordship, by oversight, I say,
Which paragraph?
yes.
Paragraph 9 and 10.
Paragraph 9 and 10, Lordship.
Fine.
10 for us.
Email.
No, para 9 doesn't say.
Necessary endorsement is.
Para 6
What?
may be seen, madam.
Huh?
Para 6.
Para 6 I saw. Para
Para
6.
6, he goes on a different line, madam. He says that he bona fide believed that it was not required to be uploaded.
Oh, no, one of the paragraph. Lordship,
At page 8.
However, the upload column specifically required only the so and so. Believing that uploading so and so would not suffice,
would suffice.
would suffice for this
because
petitioner.
it's the same certificate.
What can you do now if you have understood in a different manner, Mr. Bora?
Then one of the paragraph I said, oh, it's
Which paragraph? Yes, which paragraph?
reply question.
All right. I think I have heard you.
And Lordship, now.
Let me hear the other side
Yes.
also.
Yes, Lordship, what I want is that it is a oversight. But
Understood.
but there is only one post for ST that I have qualified. Therefore, no third party right should be affected. Therefore,
We are not on that.
Lordship would take equitable.
We are not on all that. Equity could have been given to you provided you were careful. Yes.
Lordship was at page 37 regarding his submission that he was allowed to appear, madam. 37. Lordship has read clause 8. Lordship will kindly read clause 7. Admit cards for computer-based test will be issued to all prima facie eligible candidates on the basis of the details furnished in the online application form and submission of application fees, so and so. Scrutiny of documents uploaded by the candidates will be carried out post computer-based test. Lordship has got it.
Yes.
Only those candidates will be considered called for the next stage, that is skill proficiency so and so, who are shortlisted on the basis of computer-based test and
CBT.
meet the notified eligibility criteria upon verification of documents uploaded by the candidates and
So
other
this is after the CBT.
after the disability. So that the submission that he was called for the CBT
Is of no help.
It's not
Is
correct.
of no help.
It's not correct also.
But he was called or not called?
He was called
He
for the
was
CBT. He has appeared for the CBT.
So after that, when you
After
scrutinized,
yes.
you have found that the endorsement is missing.
And Lordship, regarding that submitting of incorrect documents, my Lordship will turn to page 40 also. Clause Q, serial number 4.
Yes. How to apply?
Candidates should take utmost care. Lordship has got it.
Where?
Number 4.
Number 4.
Candidates should take utmost care to furnish the correct details.
Yes.
While filling in online application, any mistake committed by the candidate shall be his sole responsibility.
Yes.
Once the application is submitted, no change / edit will be allowed thereafter.
Yes. Anything else?
We have acted as per the advertisement, but he has already shown clause, I was supposed to show my note 42 Roman 7. So that is a basic requirement of the advertisement. We have not committed anything, any arbit, and he is correct, my lord. It was only one post. So we never know, my lord. I cannot, Lordship will not record that. The post might very well be re-advertised. Because from the impugned letter at 58, it appears that he was the only ST candidate.
50?
58.
Yes.
But if this is permitted, my lord, if we take a document, additional document, it will open the floodgates, my lord.
Where is the affidavit?
I accept it start from page 60.
Teka, এইটো dispose কৰিম এতিয়া হা তুমি থাকিবা yes
Paragraph 3 is my ground, my lord. That with regard to the statements made in paragraphs, first got it.
yes
The answering respondents stated
no you don't have to read it just give it to me
Yes.
3
3. I have taken this stand, my lord, also
yes
that
just
page
give me
fif-
the
yes, paragraph 3. In paragraph 3 itself, in the last line, I have taken that stand at
okay.
page.
Any more paragraphs you want to rely from this I'm going to quote it.
Paragraph 5, I have said, my lord, that as per the documents
Anyway,
submitted, he was not
you
eligible.
have a look at it when I'm dictating. If
Yes.
anything more
Para
needs to be
6,
quoted,
Para 6. All
you
these
just give
clauses
me
are-
those.
Yes, at all the clauses
Yes.
I have clearly written, my lord.
Take down. Anything?
One more thing.
Yes.
Only on the date of the physical test, I was informed, Lordship. And on 3-1 itself, I gave the certificate again, Lordship.
Where have you said?
Yes, Lordship, annexed, Lordship, I have annexed at
Huh?
page 60, Lordship, I have annexed the
Page? Page?
page 59, Lordship. 59.
No, 59 is that.
Email, Lordship, on 3-1, Lordship would see the letter at page 58 was only informed to me on 3-1, Lordship, on the
Okay, that
same
is
date.
right. How is it material, Mr. Bora?
Lordship, I wanted to show that only I
You
immediately.
came to know. You came to know on 3-1. Yes. Does it change anything? The fact remains that
Only
the
I.
fact remains that the apprenticeship endorsement, which was mandated under that clause, was not a part of the credentials that you had
Uploaded
submitted.
documents, otherwise I.
That's a fact, isn't it?
Is a fake, Lordship.
That's a fact.
But only that.
Okay. And also there is no averment as regards on which date this endorsement was given.
No, it
That
is
is
not
not
a
there.
dispute.
No, whatever, be it dispute, not dispute, but you have also not said that this was issued to you earlier and by mistake you have not given, because your case is that you misread. You
Yes.
misread the provision thinking that no, this may not be required. Anyway.
To my instruction, Lordship, I have definitely asked about that, Lordship.
Okay, please take your seat. Heard Mr. DP Bora, Leonard, BP Bora. B, right?
Yes.
Leonard counsel appearing for the petitioner. Also heard Mr. N. Deka, Leonard counsel appearing for
2, 3, and 4.
2, 3, and 4. Anybody else? MS so-and-so for respondent number 1. Total 4 respondents. Okay. None appears for respondent number 5 and 6. Despite I think the service is complete, na? Despite service is complete against the aforesaid 2 respondents. Stop. Fourteen to order says service complete. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the provisional list of shortlisted candidates dated 16/12/2024 to the extent it excludes the petitioner inter alia koriba. Stop. The brief facts of the case is that on 27/2024, an advertisement was issued for the recruitment of non-executive personnel, including the position of junior engineering assistant 4 within bracket PNU, with a total of 10 posts available. Amongst these, one post was reserved for the ST category in the Guwahati region, along with other positions. The petitioner belonging to the Lalung tribe, which is recognized as ST Plains under Constitution within bracket Scheduled Tribes Order 1950, accordingly applied for the said post. However, in the list of candidates qualified in the CBT held on 29 September 2024, which was published on 16/12/2024, the name of the petitioner was not included, was not shortlisted therein. However, since the score of the petitioner in the CBT was not known to the petitioner at that time, he did not agitate as not being shortlisted for the skill stroke proficiency stroke physical test, and anticipated that his name shall be included in the final selection list. Stop. It is the specific case of the writ petitioner that on 3/1/2025, i.e., the date on which the interview for SPPT was scheduled, the reasons for the petitioner's rejection were communicated to him. The reasons for rejection were provided in the remarks column, which stated as follows, quote unquote, page 9, A to A. Aggrieved by the aforesaid rejection, the present writ petition has been filed. Mr. B.P. Bora, learned counsel for the petitioner, submits that the petitioner has all the prescribed qualification and fulfills the eligibility criteria. Hence, the non-inclusion of the petitioner and hence the rejection of the candidature of the petitioner is arbitrary and illegal. He further submits that the petitioner had enclosed, has uploaded the requisite national apprenticeship certificate while uploading his application online. However, due to misreading of the requisite that is there in your condition, in your paragraph, I can't.
Page 14 as the ground F, I have said oversight and.
No, you can't give two different country grounds. Submits that due to misreading of the eligibility clause, inadvertently the endorsement certificate as required was not uploaded. However, the requisite endorsement is issued by the chairman, Boiler Attendant Examination Board Assam, within bracket, respondent number 5 and 6, and the same has also been enclosed as Annexure 4 to the writ petition. He therefore submits that since the petitioner has scored 64 62 in the CBT, na?
Yeah,
In the CBT,
page 15.
and is the sole ST candidate as per the Guwahati region is concerned. No, not sole. The one post,
One post, and one candidate only.
And from 58, it appears there is only one
a
candidate.
sole candidate to the single to the one to the post to the one post reserved for the ST, comma, his case may be considered equitably. Correct? You want to add something? If you want to add, I will add. Tell me what. Stop. Per contra, Mr. Deka, learned counsel appearing for the respondent, submits that the petitioner, having not uploaded the requisite endorsement of equivalence certificate as required under the terms of the advertisement, comma, his candidature has been rightly rejected. He further submits that there cannot be any relaxation to the eligibility criteria and non-furnishing stroke non-uploading of a required document on the pretext of misunderstanding the qualification parameter stroke work experience criteria clause stipulated in the advertisement is of no consequence. He further draws the attention of this court to clause, which is that careful clause? Deka?
Q,
Huh?
clause Q4 at 40.
To clause
Q4.
to clause Q, to subclause 4 of clause Q of the advertisement, which stipulates the instructions as how to apply online application. And it is clearly stated therein that any mistake committed by the candidate shall be his, her sole responsibility, and that candidates should take utmost care to furnish the correct details while filing in online application. Stop. I have given my anxious considerations to the arguments advanced by the learned counsels appearing for the parties, and have perused the materials available on record. Apt at the outset to refer to the advertisement dated 27/2024, relevant clauses of the aforesaid advertisement reads as hereunder. Quote unquote কৰি দিবা এইটো page 24 পৰা হ'বতো। I don't think the entire advertisement is required. You give that page 24 A আৰু এটা chart এটা আছে clause A বুলি A to A খিনি দিবা মই লিখি দিছো A to A page 24 তাৰপিছত B to B যোনটো দিছো only that P part, okay, but draw the chart and then just provided that P part. Then after this, I think 28 B, huh?
Yes.
Then B, okay, dot kori B, C2, I think B, the entire part, right?
If your lordship sees the order dated 8/1/25, that part is quoted already.
But I think I will need the other clauses also.
But that chart box part is quoted there.
Okay, which order?
8/1/25.
Here it's 8/1/25.
That part is there.
Then B part to plus C to C diba. A to he relevant a junior engineer assistant PNU to a my circle code is. Then after this,
Page 37.
page 31, is it? No, 37. 32 also? 32 is not
32 is
required.
not required.
32 is not required. Then 36 is also not required. 37.
7 and 8.
37, no? 7 and 8. 11 and 38. Clause. Then 16, no, not required. I think that's all. And then 40.
40 and also 42.
40 ৰে গোটেইটোৱে দি দিবা। In 40 a clause to গোটেইটো A2A মই দিয়ে দিছো। How to apply clause to গোটেইটোৱে দি দিবা।
30 plus 7.
40? Then page 42. Yes. Page 42, 13 or 7 to. Call 17 to 13, 7 delay hobo. That's all, huh? Reading of the so and so etu episode bharai di tarpisot lekha that as stated above, the ground of rejection of the petitioner's candidature for the subject selection is for not enclosing the endorsement from Boiler Authority of Assam as equivalent to BCC second class while submitting the apprenticeship certificate online. The short question thus is whether for not submitting of one of the document in order to in order to satisfy the appointing authorities as regards the qualification of the candidate is fatal to the selection process. Stop. The qualification parameter and work experience, the post-wise qualification parameters for refineries division to the subject post which the petitioner has applied mandates that the National Apprenticeship Certificate in Boiler Attendant under the Apprentices Act 1961 should be submitted along with due endorsement of equivalence to the second class boiler attendant certificate of competency by the competent boiler authority of the state of the refinery unit for which the candidate has applied. It further appears that it is clearly prescribed under the terms of the advertisement that candidate must ensure to upload clear and legible self-attested scan copy of documents such as matriculation stroke, higher secondary, etc., and any other prescribed documents ascertaining his stroke her eligibility for selection process. It is further specified that there has to be one single upload file against each category of documents. It is further specified that failure to comply with the aforementioned provision of uploading documents shall render the candidate ineligible for selection process without any liability on the corporation in this regard. Where is that clause that after the scrutiny is done after the CBT?
7,
Page
37 plus 7.
It further appears that admit cards for computer-based test within bracket CBT will be issued to all prima facie eligible candidates on the basis of the details furnished in online application form and submission of application fees. It further appears that scrutiny of documents uploaded by the candidates will be carried out post CBT, and only those candidates will be considered call for next stage, i.e. skill stroke proficiency stroke physical test within bracket SPPT, who are shortlisted on the basis of computer-based test and meet the notified eligibility criteria upon verification of documents uploaded by the candidates and other parameters. Stop. It further appears that as per the instruction stipulated in the advertisement as how to apply in the online portal. No? It is specifically stated that candidates should take utmost care to furnish the correct details while filling in online application, and any mistake committed by the candidate shall be his/her sole responsibility. And that once the application is submitted, no change/edit will be allowed thereafter. Stop. What transpires from the above is that filing of all is that submitting all the testimonials in support of the qualification criteria is mandatory at the time of uploading the form in the online portal, and any failure to submit any document shall render the candidature ineligible in the ineligible to be considered for selection in the subject selection process. It is further apparent that the scrutiny of the documents are done after the CBT test. In the present case, it appears that after the CBT test was held, upon the scrutiny and verification of the documents submitted by the petitioner, upon finding that the apprenticeship certificate submitted by the petitioner does not have the requisite endorsement certificate, his candidature his name was not shortlisted for what is that SPPT. Stop. So this is correctly I've said. This takes me to the reason.
58.
No, not that. That I have already quoted. To the ground taken by the writ petitioner for not enclosing the requisite endorsement certificate in the writ petition, comma. Relevant paragraphs of the relevant paragraphs reads as hereunder. Para 4, that paragraph 6, para 6. Reading of the aforesaid, it is clear that it is apparent that admittedly the petitioner did not upload the requisite endorsement certificate while uploading the National Apprenticeship Certificate, believing that uploading the National Apprenticeship Certificate would suffice for the recruitment process. Stop. The aforesaid explanation cannot be accepted inasmuch as the candidate ought to have been vigilant and careful while uploading his documents, especially consistent with the qualification stroke eligibility criteria stipulated in the advertisement. As stated above, the aforesaid certificates are mandatory and non-failure of the same renders the application of the candidature ineligible for further selection. That being so, this court finds that being so, this court does not, that being so, the rejection of the petitioner's candidature appears to be in conformity with the requirements laid down in the advertisement. Hence, the writ petition fails, no cost. I will edit it, huh? You will get it probably tomorrow. I'll have to edit. Sorry, Mr. Bora.
My lord, it's regarding departmental proceeding, my lord. Stay order,
36
stay order has been granted, my
Supplementary
lord.
কোনটো হয়? Huh? This is item 36.
36.
Yes. What is this?
My lord, it's regarding departmental proceeding.
Yes.
And my lord, stay order has been granted and I have filed an I for modification of that stay order. My lord, the writ petitioner has been arrested, caught red-handed for taking bribe of rupees 50,000.
Which is the order which is you want vacation of?
My lord,
21?
my IA
Yeah.
2585 of 2025, page 51,
The order is 21.5?
21.5,
Just read.
page 51 onwards, my lord.
Mr. Sharma, you have filed objection.
The writ petition, my lord, will suffice one.
Page
Page 51 onwards, my lord. My lord, relevant page 52, my lord. May I read? 21/5/2025. Page 52, my lord.
page
51 onwards, relevant page 52,
51.
51.
Yes.
Next page, my lord, 52. Dated 21/5/2025.
Yes.
Heard so and so, assisted by so and so, pursuant to the issuance of memorandum of charges dated so and so, issued by the registered Guwahati University, a disciplinary proceeding was initiated against the petitioner. Thereafter, the inquiry officer submitted its report on 13/2/2025. In the said report, the inquiry officer came to the conclusion that the charge of misconduct brought out against the charged officer is proved beyond any reasonable doubt. The inquiry officer further recommended that the petitioner be dismissed from service pursuant to clause 46(8) of the Guwahati University Employees Service Commission Conduct and Appeal Rules 1970. 3. The inquiry report was furnished to the petitioner by the registered Guwahati University by a communication dated 13/5/2025, wherein it is stated that in terms of resolution number so and so of the Executive Council Guwahati University, adopted in its meeting held on 21/3/2025, the report of inquiry officer in connection with the departmental proceedings drawn against the petitioner has been accepted by the council. It is important, has been accepted by the council. That word, accepted, whether it should be received or accepted, the entire matter revolves around that word, meaning,
Where?
paragraph 3,
It is stated.
last 3 lines, in connection with the departmental proceeding drawn against the petitioner has been accepted by the council. That
Paragraph
word
3.
Paragraph 3. That word accepted. It further states that as
No,
per
where in paragraph 3, I don't get that.
paragraph 3, page 52, Miller.
Yes.
Last 4 lines, Miller. I'm reading entire paragraph.
Yes.
Short paragraph. The inquiry report was furnished to the petitioner by the Registrar Guwahati University by communication dated 13/5/2025, wherein it is stated that in terms of resolution number so-and-so of the Executive Council Guwahati University, adopted in its meeting held on 21/3/2025,
So you mean to say it was not accepted?
Milord, we have received the one of the dictionary meaning of the acceptance is that, Milord, to receive with Milord with an intention to do further, Milord.
Anyway,
Some-
but then as per the resolution, the report was forwarded to the petitioner.
Yes, Milord, that is why, Milord, and
Huh?
subsequently,
So-
Milord, no action has been taken. That report has been forwarded to the delinquent.
So here, that means I'm sorry,
Mira.
because I think Mr. Sharma, your case is that biasness that they had already accepted the inquiry report. Correct? That is your case.
One of the other ground is that, my lord, under Rule 9 of the Assam Services and Disciplinary Appeal Rules 1964, the inquiry officer has exceeded the mandate and the power
Mr.
granted.
Fukan, right?
Milord.
Mr. Fukan, what is wrong in this order? Why today you have come for vacating this? Whether it is accepted, not accepted, this has to be ultimately taken up for final hearing.
Milord, since Milord, we could
Because
not-
prima facie a case is made out, and that is why an interim order has been given. What is wrong in that?
Milord, that is why, Milord, that accepted the meaning of the
Mr. Counsel, that has to be now taken up for hearing. Whether because apparently it says accepted. Accepted as we understand, you have accepted it, and after that you have forwarded. That is of no good.
forwarded.
Because you have already made up your mind. Then what is the use of forwarding the inquiry report? The entire opportunity goes for waste. It's as an useless formality. You see, I am not saying, I am not hearing the matter today.
Milord,
I am only hearing the I.
Milord, on
The interim orders are passed on a prima facie case being made out. The petitioner has made out a prima facie case on the now tomorrow after hearing completely after hearing, we don't know what we will what this court will hold. But what is wrong in this
Milord, on
order?
the last
Because
on the last occasion,
you are agreeing that yes, it is accepted is there, but the word accepted is a misnomer in this case because you did not accept, but you merely received. This is what you want to say.
Milord,
But how can now? How do you convince this court on that?
only that aspect, Milord, the entire
The records will have to be seen.
Milord, since Milord, the annexers, Milord, and Milord, on the last occasion, Milord, this honorable court has, Milord, directed that the entire matter, along with the writ petition and IA, should be, Milord, taken up together, Milord.
Is there an order like that?
Today, Milord, how did-
Where is that order? Then the
not
matter
done.
has then the writ petition will be taken up. Why the IA? If the IA, the writ petition can be disposed of, pleadings are complete in the writ petition.
Milord, I have filed the affidavit in opposition in the writ.
Yes,
This one,
pleadings complete.
pleadings are completed, my lord.
So we'll have the writ petition fixed for hearing then. What is the use of having this IA fixed for hearing? Today the IA is listed before this court.
There are two IAs, in fact, my lord. One IA was disposed of on the earlier occasion. This is the IA which is.
Which is that first IA?
My lord, that was for amendment of the cost
Cost
title.
title.
That was a minor procedural lapse on our.
Anyway, this IA appears to have been listed today.
Yes, ma'am. It is in orders, my lord, because of that reason, my lord.
On the last occasion, Milord, Harvey, Milord, we agreed, Milord, that the entire matter would be taken up today. Since, Milord, it's a, the order
But
was
it has
passed-
to, the entire matter will require to be heard. I've understood.
Milord.
You are ready, Mr. Sharma? Then we will hear the writ petitioner first.
Milord.
If you are ready, we'll hear the writ petitioner. We'll hear the writ petition.
Very short compass, Milord. Help করি দিন।
You're ready, right, Mr. Sharma?
Yes, ma'am.
Yes. You can just give
Yes.
the brief
Yes, my lord.
first.
Now, what had happened, my lord, was that the petitioner was a registrar in the Guwahati University. Thereafter, he was academic registrar. Thereafter, he was sent on
He was a
academic registrar, my lord.
academic registrar.
Yes, ma'am. Thereafter, he was sent on a lien to Bhattadev University, my lord, in Bozali district. There were allegations against him. He was caught by the police. The veracity of that is yet to be determined, my lord. He was caught allegedly taking a bribe. So that matter was before the this honorable court, my lord, on the earlier occasion, pertaining to his release from service from the Bhattadev University. Thereafter, my lord, the writ petitions and the writ appeal did not go the petitioner's way, my lord. Thereafter, he was directed to join his parent university, which is the Guwahati University. When he joined the Guwahati University, my lord, he was immediately put under suspension from that date itself, on the date of his joining. Then his suspension was further extended by a period of 3 months. All of that were in order, my lord. Thereafter, a disciplinary proceeding was contemplated against the petitioner. There was an inquiry officer which was appointed by the university. He's a retired IPS officer, and he was also versed in law.
He was
Versed in law, my lord. He has a law degree. He was not a legal practitioner, but he was versed in law, my lord. Then we approached this honorable court for the assistance of a defense or a legal practitioner as a defense assistant for the petitioner. That matter, that aspect was rejected by this honorable court, because ideally, my lord, it is the presenting officer who ought to be a legal practitioner, not the inquiry officer. But our ground was separate, but that matter was dismissed.
because the inquiry officer was
He-
from the legal
Yes, because
background.
it-
That is why you won.
Yes, my lord. That was our contention.
But anyway, that was rejected.
That was rejected, my lord. Those issues are the background of it, my lord. Then the inquiry commenced, proceeded. The fact of the matter is, there was a witness list which was communicated to the petitioner. That witness list has been tinkered twice without any intimation to the petitioner.
What do you mean by tinkered?
My lord, incumbents have been added, incumbents have been taken out.
You've been added. They have modified.
They've modified. That's what had happened, my lord.
And the final witness list is not given to you.
It is given to us, my lord. It is a part of the petition, my lord. Initially, when it was conveyed to us that these are the witnesses which will be there as prosecution witnesses, that list was not adhered to in its entirety.
So, after you submitted your show cause and all, the
Yes.
witness list was modified.
Was modified, my lord. We can show it now. It's on record, my lord.
Hmm.
Thereafter, the inquiry officer proceeded to hear the matter.
Did you take up this issue before the inquiry officer that the modification of
The modification was taken up subsequently, my lord. After that date, because there are a lot of dates, my lord, which are
but not at that at the
not
time of
on-
starting
no,
of the
no,
inquiry?
No, man. Thereafter, the inquiry officer happens to
And
be-
what names have been added?
My lord, yes.
Now, these names have been furnished to you before the start of the inquiry.
No, there was a list of prosecution witnesses which was furnished to me before the inquiry started.
So that list did not figure out the
No,
added
no,
one.
my lord. There were 7 incumbents. Now there are 6 incumbents initially. Thereafter,
So one of your ground is also
Yes.
fairness in the
Yes.
inquiry proceeding itself.
yes, my lord.
That is one of your
That is
ground.
one of the ground. The
Violation
other,
of natural justice.
Yes, my lord. That is one of the ground. The other ground is the element of bias. The reason we are stating the element of bias, my lord, is that ideally there is no bar for a departmental proceeding and a criminal proceeding to proceed simultaneously. But the entire set of events, my lord, had happened in Bhattadev University, pursuant to which he was under suspension and the departmental proceeding had proceeded. The inquiry officer is a retired IPS officer from the vigilance department, and it's the vigilance department who's conducting the inquiry. That is one leg of the other leg of our my lord, the argument. Third leg of our argument, my lord, is the fact that your lordship had seen that the executive council, by a resolution, has accepted the inquiry report. If the word acceptance only pertained to receiving a document, it would not have required a resolution from the executive council, madam. That is our third ground.
There
And
is, I think, even this court has authored a judgment in this point about accepting and then
My lord,
forwarding.
I've bought those judgments, my lord.
This court's judgment.
Is this court's judgment, my lord. The matter now is pending a final adjudication before the Honorable Division Bench, my lord. But the issue has been settled by this Honorable Court on an earlier occasion. Now, my lord, we'll kindly come to page 97, the other element of bias, where I'll read the recommendation, my lord, where the inquiry officer has violated the mandate under Rule 9. As the charges of misconduct against the charged officer, Dr. So-and-so, has been conclusively proven beyond any reasonable doubt, the inquiry officer, my lord, I recommend his dismissal from service.
He's acting as if he is the disciplinary authority. He is supposed to be just recording the finding and forwarding it.
Absolutely, my lord. The documents, the records are apparent on the face of it, my lord.
This is one instance where you are saying that the inquiry officer was biased.
Bias.
What
Yes.
was the other
That he happens to be an IPS officer from the
That
Vigilance
is-
Department, my lord.
IPS from?
He is a retired IPS, my lord. He was from the Vigilance Department, and it is a Vigilance Department which is currently prosecuting the case against the petitioner, my lord. That issue has been dealt with by the Honorable Supreme Court in the matter of Stanzin versus Toetsu, my lord, 2014 matter. That is two of the grounds. The other ground being that the witness list was tinkered with. And those grounds are sufficient for this Honorable Court to interfere, my lord. Because the inquiry officer has
All right,
overstepped his
let's
mandate.
see.
Yes, my lord. My lord, I have framed the points for your lordship's determination subject to any final consideration, my lord, at page 17.
Page?
17, my lord. Page 17, paragraph 38.
Yes.
The above narration of facts indicate the following fundamental fallacies that run counter to the law governing disciplinary proceedings. The inquiry officer had exceeded his mandate as granted under the provisions of the Assam Services Discipline and Appeal Rules 1964. The Executive Council had already accepted the recommendation findings of the inquiry officer, thereby vitiating the entire process as well as rendering the response/reply sought from the petitioner as fruitless. C. The inquiry officer and the respondent university had tinkered with the list of witnesses thrice to bring their desired conclusion into play. And the inquiry officer refused to grant the petitioner the right to cross-examine the PWs in spite of the liberty granted to the petitioner by this honorable court. So, apologies, my lord, by judgment and order.
You're not allowed cross-examination.
Yes, my lord. The liberty was granted to the university, my lord.
You don't
which
need a
was-
liberty. That is your fundamental
In fact, what has
basic
happened-
principle.
In fact, what had happened, my lord, is that when we were made aware of the inquiry officer being of the background that he was, we approached this honorable court, and there was no stay granted. And the matter was immediately, my lord, the matter was closed, my lord, with the finding by this honorable court that we have no dispute with. But since we've already missed 2 dates because of the matter, my lord, the liberty was granted by this honorable court that I'll be given a chance to.
But despite that, it was not given.
No, my lord. Your lordship will kindly come back to page 17, my lord. I have just prepared a table
Yes, yes.
for this honorable court's perusal, my lord. Ready
Yes.
reference. Your lordship sees the list of PWs, my lord.
Yes.
The first 2 names, my lord, because it appeared on 6-1 and 16-1, I was 6-1, it was denied to me.
Yes.
I had preferred an application also in that regard, pursuant to the honorable court's order, but the right to cross-examine the my lord PW1 was still denied to me. And serial number 7, my lord, Bodrul Islam. He is
Yes.
the newly added witness. Now I'll substantiate, my lord, by way of this petition, my lord. Now, your lordship will kindly come to page 34 of the writ petition. Page 34.
Yes.
Page 34, my lord, is the memorandum of charges. There are
Page 34.
34, my lord. It's the memo of charges, my lord. The memo of charges would indicate the entire set of events which had occasioned
Yes.
disciplinary proceeding was pursuant to an event that had taken place in Bozali. But I'm not on that, my lord. Your lordship will kindly come to page 40, which is the list of witnesses.
Yes.
Your lordship sees that?
Yes.
Yes, there are 5 names, my lord. Jiaur Pasa, who is the complainant. Sri Angad Brahma. Then 3, the officer in charge of the ACB police station come SP Vigilance and Anti-Corruption. 4, Professor Birinsi Kumar Das. 5, the registrar, Bhattadev University. 6, the academic registrar, Guwahati University. Now these are 6 names, my lord.
This is the list which was given to you.
Yes, my lord. Then
First list.
Yes. Then there was a communication on the 1st of January 2025. Your lordship will come to page 59. 59, my lord.
Yes.
Now your lordship will see Ziaur Pasa was there in the earlier list. Anjad Brahma was there in the earlier list.
Yes.
Rafiqul Hassan Chaudhary, I do not understand whether he is the SP or his name was added, because 3 and 4, Singharam Mili and Rafiqul Hassan Chaudhary, those are the 2 additions, newly added names, my lord.
Who are the new ones? The Singha.
Serial number 3 and serial number 4, my lord. Serial number 3
Three, you said could be number 3 also.
could be, because number 3 was given officer in charge, ACB police station. We are not sure as to whether that
And
is Rafiqul Hassan Chaudhary.
Singharam Milli was not there in that list.
No, my lord. And 5 and 6.
5 and 6 were there.
5 and 6 were there, my lord.
Yes. Yes.
That list had been tinkered with. There
Tinkered is quite
It's
a
a-
strong word.
Yes, my lord. Yes.
Yes,
yes, my lord.
they may bring new witness.
Yes.
But there
can.
is a manner,
There-
there is a procedure.
Yes, my lord. Yes,
So
my lord. I
if
apologize.
they have adopted a fair procedure, then that's a different thing.
But there was no prior intimation, my
So
lord.
don't
And
use that word tinker.
I apologize, my lord. I apologize, my lord.
Yes.
Then, my lord, we come to page 65. Page 65. No, my lord, I apologize. Page 78. Page,
Page,
78.
page?
Page 78, my lord. Page 78.
7, 8.
7, 8, my lord. 7, 8. So this letter, my lord, was preferred by the petitioner after the earlier writ petition was decided by this honorable court.
Yes.
The earlier writ petition was decided by the honorable court on 27th, by which time there was no stay on the proceeding and the proceeding had already commenced. Now, after the matter was closed, I preferred this letter, my lord, at page 78 before the inquiry officer. In this regard, I beg to state that I could not cross-examine only 2 prosecution witnesses, 1 and 3, while I could not do the same for other prosecution witnesses due to the non-consideration of my defense assistant being a legal practitioner. The issue being sub judice in WPC number so-and-so before the Honorable Guwahati High Court was finally disposed of by judgment and order dated 27/1/2025 under reference above. However, the court, Honorable Court, in paragraph 20 had granted your good self the liberty to consider my application for cross-examination of the prosecution witness. As such, I fervently pray before your good self that I may be allowed the opportunity to conduct the same, as the entirety of my service career is at stake. The same was not done, my lord.
Yes.
It was not responded to. Then the inquiry officer conducts his inquiry in a manner he deems fit, my lord, and he recommends my dismissal. And the executive council, my lord, by way of a resolution, had not merely received.
Where is that resolution?
My lord, your lordship will kindly come to page 80, my lord. The resolution has not been stated, is not a part of the record, my lord.
You have a copy of the resolution.
Don't have that copy.
That is required.
This is to inform you that as per resolution number so-and-so of the Executive Council, Guwahati University, adopted in its meeting held on 21/3/2025, the report of the inquiry officer in connection with the departmental proceedings drawn against you
Has been accepted.
Yes.
What? It is absolutely clear.
That
It
is
has
fine.
been accepted. Absolutely clear.
The law is also laid down, my lord. I can furnish copies of the.
You have everything.
I have.
I think we can resume after. I
Yes,
think
ma'am.
it's already
Yes, madam.
1.
Yes, madam.
We'll continue at 2.
Yes, madam.
Yes, Mr. Sharma, Mr. Oronia. Well, why everybody is approaching the bench? I'm going to sit at 2. Any accommodation?
I may be giving indulgence to
Which matter?
to mention an item 1. One Supreme Court lawyer was engaged in their case at 10:30.
Item number 13.
13, my lord, item 13. He had asked the-
13 order has been passed, Mr. Sharma.
No.
Yes, Mrs. Saranya?
Only my lord. Can you be taken tomorrow, my lord, at least?
That we had given him, we asked him tomorrow, he said 17, but Mr. Saikyas has to be here at
Yes.
2. You asked Mr. Saikya whether they are comfortable tomorrow or not. Only the date can be fixed, nothing else.
Because my lord, he missed.
That is all right.
tomorrow.
You don't have to be here at 2 o'clock. Give a consent date to the court master. I will give a date. I had asked him tomorrow, day after tomorrow. Your junior was not.
He missed. He actually it was to mention at 2.
No,
He had asked him to mention at 2 because for the timing.
no,
Tomorrow.
nothing doing. These things will
Tomorrow.
not happen like this.
Okay, tomorrow.
Advance intimation has been also given. That intimation was not 2 o'clock. Please do not make unnecessary submission before this court.
No, he was
The,
asked to take at 2.
Mr. Counsel, Mr. Senior Counsel, please be mindful of what you are submitting in the court because your junior had also given an advance in the morning, has already
what I
informed,
did.
and
That's
it was not at 2. That was an adjournment request.
He made
Yes,
adjournment
Mrs. Aranya,
23, my lord. Need some accommodation, my lord.
this matter
My lord.
is, I have almost,
My lord.
no, in fact, I have worked out the draft
My
also.
lord.
So there are some clarification for which I had kept
My
today.
lord.
So if you are having difficulty today,
Difficulty today, my lord. Maybe after 22, my lord.
all right.
23, 24, 25, any date, my lord.
No, as prayed for by Mr. M. Saranya, Leonard so and so, on the ground of personal difficulty, despite the matter being part heard, which is not opposed so and so, this court fixes on so and so.
23.
However, on that date, no further adjournment is going to be given. Yes.
23. My lord.
The charges of the inquiry officer.
Yes.
So, while this matter was being adjudicated, my lord, Ramzan Khan and B. Karunakar was discussed, but I'll take your lordship through those paragraphs, my lord. Your lordship will kindly come to paragraph 13.
Yes.
This is the finding of this court, my lord.
Yes.
As observed above, the importance of furnishing the report of the inquiry officer to a delinquent before the same is acted upon by the disciplinary authority has been clearly laid down by the Honorable Supreme Court in a catena of decisions, including the above referred to cases. It has also been laid down that while the requirement of informing the delinquent of the proposed penalty has been done away with by the 42nd Amendment of the Constitution of India, the requirement of having the views of the delinquent before concurring with the findings of against such delinquent by the inquiry officer would still be an essential requirement. Now, my lord, we'll kindly come to paragraph number
15.
15, my lord.
Yes.
After the remand by this court with a direction for holding a de novo inquiry, it appears that the same error of law has again been committed by the disciplinary authority even without going to the aspect of the challenge that no witnesses were examined in the inquiry, which however has been disputed by the learned counsel for the respondents. The aspect of concurring with the findings of the inquiry by the
Okay.
disciplinary.
And 16, till 16, no?
Yes, my lord. Yes. Yes.
And that's all from this?
That's all, my lord. Then I have, then my lord has been furnished with a copy of Ramzan Khan also.
Yes.
The relevant paragraphs are paragraph 17 and 18, my lord. 17 and 18.
Ramzan, I think, would be,
My lord, the internal page will be 5.
no, one
Yes,
second.
yes.
In one of my decision also I had referred to Ramzan. That's what I was trying to find out. Yes, paragraph.
Paragraph number 17 and paragraph number 18, my lord.
Okay.
Should I be reading that, my lord?
No need.
Okay, okay. Then, my lord, will kindly see. I could not find a copy.
What is that?
My lord, the B. Karunakar. The other matter, my lord.
That is not available a print.
No, my lord. So I've gotten 2 hard copies of it, my lord. Paragraph number 28 and paragraph number 29.
Citation to Diok, more SSC to us. It probably I দিব বেদিকায় huh? Oh, ECIL.
Yes, my lord.
Yes.
And now, my lord, the
Paragraph
number 28 and 29, my lord.
28 and
29.
Can I write
Yes, my lord.
from your office or from your senior's
My lord,
office?
this is from my office. My senior's office, my lord.
28.
And 29, my lord.
Yes.
28 and 29. And thereafter, my lord, I'll take your lordship
And
to.
print laga. Yes.
Thereafter, my lord, I'll take your lordship.
It's all right. Just give me the.
My lord, 2014,
Yes.
3 SCC, 636.
Give him the list and
Yes, ma'am. Yes, ma'am.
give him the list with the paragraphs. Huh?
Yes, my lord. My lord, that issue is slightly on a different aspect. The fact that if
Which one?
My lord, stands in this recent judgment, my lord, that if 2 sets of inquiry, criminal and disciplinary, are proceeding on the same set of facts.
That you
that-
see, you have not demonstrated that
Yes.
why it should not, because you see, there is no bar.
There is no bar.
It can
Absolutely, my lord, yes.
simultaneously go ahead. In fact, an acquittal in a criminal charge shall also not automatically discharge you from in the disciplinary proceeding. The
absolutely.
standards of proving
Different.
is different. Here it is
Preponderance
preponderance
of-
of probability, where there it is beyond reasonable doubt.
Yes, ma'am.
So those are different.
My lord,
There
this
is no bar.
But there is a reason why I'm on harping on that, my lord. The reason being, if for some reason, my lord, subject to what your lordship finally determines, if the entire disciplinary process is sought to be revisited, subject to what your final lordship finally says, the bias of the executive council is already reflected. No, because, my lord, now revisiting the entire departmental procedure pertaining to the petitioner would merely be.
See, as at this moment, I am with you that the issuing of the second show cause notice was not right.
Yes.
That apart, see, till then I am with you.
Yes, my lord.
But now it also appears that the inquiry officer has also clearly indicated what is the punishment, which appears that he has
Exceeded, my lord.
exceeded and that the biasness.
Yes, my lord.
Now that is an aspect which after hearing only I can decide.
Yes, ma'am.
Now, but it is, I'm trying to appreciate the argument that you have made
Yes,
in the
madam.
context of your facts of the case.
Yes, madam.
Because the fact that the inquiry officer, Mr. Fukar, you please hear because you have to respond there. The inquiry officer having already indicated that this is the punishment. Would that indicate? Because ultimately, what is it is the fairness
My lord.
which has to be there. The inquiry has not to be only fair, but it must be so
it should
that
appear to be.
it appears to be fair, correct? So where is the appearance of fairness here when the inquiry officer has already said Give him this punishment.
Dismiss him.
I mean, after receiving inquiry officer, you have taken a resolution.
Yes, my lord.
Dismiss it.
Yes, my lord.
And then you furnish a copy. What is the use of giving that notice
Yes, my lord.
after the inquiry officer have already decided the punishment?
Yes, my lord.
After the disciplinary authorities have already accepted the punishment.
Yes, my lord.
Now that the only thing is that to that extent it is understandable, we can return, we can send it back to that stage.
Yes, my lord.
But suppose we find that the inquiry officer from the beginning has been biased, then the entire inquiry will go.
Yes, ma'am.
Then the entire inquiry will go. Now, Mr. Sharma,
Yes, my lord.
for the entire inquiry, one, you have said that during the, now at what stage was that list changed?
Yes, my lord.
Two witnesses have been added?
Yes, my lord.
At what stage? Where are those pleadings? And how were you prejudiced?
Yes, my lord.
And which is that you had also shown that
Yes.
you were not allowed to cross-examine.
I was not allowed to cross-examine, my lord. My lord, my prayer for cross-examination, my lord, was is at page.
Please,
60.
you see, the other point you have drawn
Yes,
home, huh?
yes, madam. Yes, madam.
Now, in order
I
to
understand.
substantiate
The
your
bias element. The
correct,
entire
you
process.
please
Yes.
show
Yes, my lord.
how
Will do, my lord. Your lordship will kindly come to page 68. Page 68.
ভাৰ্গৱ এটা কাম কৰিব পাৰা, তোমাক মাতি দিম, তুমি সেইখিনি চেছ কৰি লোৱা. When we call, you come. Page
68, my lord.
68.
This was the earlier writ petition, which was preferred, my lord, for availing the assistance of a legal practitioner as a defense assistant. This honorable court heard the matter at great length, my lord.
Yes.
Thereafter, my lord will kindly come to page 79. 77, my lord. 77. I apologize, my lord. 77.
No problem. You don't have to apologize. 77.
77, my lord.
Yes.
77, my lord. This is a part of the paragraph number 20. This last sentence, not the last line, my lord, the last sentence.
Yes.
The above being said, in the event the petitioner has not been able
One
to.
second.
Yes.
The above being said.
Yes,
Yes,
my
yes, yes.
That the above being said, in the event the petitioner has not been able to cross-examine the three witnesses on 16/1/2025, the IO should consider giving an opportunity to the petitioner to cross-examine the
Now,
witnesses.
what is there to show that on 16/1/25 you were not allowed to cross-examine?
My lord.
The inquiry report is here. The proceedings are here.
The proceedings are here, my lord. In fact, the inquiry report starts at page 82.
I think after this you were about to go there only, right?
Yes. And
Or you wanted to say something
I
more?
want to go to page 78, the immediately next page. My lord.
Yes.
Pursuant to that order, my lord.
Yes.
I
You had sought for to cross-examine.
Yes.
An opportunity.
Yes. In this regard, I beg to state that I could cross-examine only two prosecution witnesses, number 1 and 3, as mentioned in so-and-so, dated 1/1/2025. Now, 1/1/2025, my lord, is at page 34. This is relevant, my lord. 34, page 34. 34 is where the memorandum of charges start from. This is the memo of charges, my lord.
Yes.
Dated 23/10/2024.
Yes.
Then the relevant list of witnesses, my lord, is at page 40. Page 40.
Yes.
Yes. Now,
that you have shown.
No, my lord. So this is pursuant to the memorandum of charges which was issued in the month of October 2024. Now, my lord will kindly come to page 59. This is the list dated 1/1/25, which the petitioner has stated that serial number 1 and 3 could not be cross-examined. This is where the disparity comes into play, my lord.
Where have you said that?
Yes, my lord. That submission is at paragraph number 30 starts at page 13. Page 13, my lord. Page 13. And paragraph 30.
One three.
Yes, page 13. Yes, my lord. And paragraph 30.
Yes.
That pursuant to the liberty granted by this honorable court, the petitioner had preferred an application dated 31/20/25 before the inquiry officer, praying for an opportunity to cross-examine the prosecution witnesses while admitting that the petitioner could cross-examine only 2 out of the list of witnesses arrayed in the communication dated 1/1/2025. The said witnesses were Ziaul Pasha on 16/1/2025 and Shri R.H. Chaudhary on 27/1/2025. At this point, it is imperative to mention that the list of witnesses appended to the Memorandum of Charges dated 23/10/2024, which is at page 34, my lord, and the list of witnesses arrayed in the communication dated 1/1/2025, annexure N at page 59, are different. The said application was not responded to by the university.
The said
Application, my lord, the application which I preferred was not responded to by the
No,
university.
but in that application, what did you ask?
I asked that I be given the permission to cross-examine the witnesses.
Wait.
Yes, my lord.
This is to inform you that as per resolution, no, not that. Where is that letter go? Yes. Professor Guru Prasad so and so, academic so and so, prefer this for your consideration in allowing me to cross-examine all the prosecutor matters as mentioned in the letter. Who is this Guru Prasad
He
Khatunia?
is the petitioner, my lord.
I so and so prefer this so and so allowing me to cross all the prosecution witnesses as mentioned in the letter summon. Now letter you have mentioned one is summon is 1/1/25.
Yes, my lord, which is at page 59.
And what is this judgment?
Judgment is
that okay?
yes, my lord.
Now
Judgment-
but you are talking about the witnesses in 1/1/25.
yes,
Now in this regard, I believe I could cross-examine 2 witnesses.
yes.
While I could not do the same for the other so and so due to the non-constitution of my defense assistant being a so and so. The issue before the so and so was finally disposed of. However, the honorable parliamentarian had granted. So it appears that you are only talking about the first list.
No.
Whatever.
Yes, yes.
But the first list also, it appears you have only examined the first 2.
Yes, madam.
The rest you could not examine because at that moment your High Court case was on.
Yes, there was no stay.
Whatever be it, ultimately when you had approached the High Court says ki no, let the inquiry
Yes.
officer give him
The
opportunity in case on 16 so and so date he did not get that opportunity.
That,
Now where do we get that on 16th you were not given that opportunity?
my lord.
Or where have you said here?
Yes, my lord. We have said that, my lord.
I'm not going to those
Page
the confronted facts because
Page
these are
17.
admitted, isn't it?
Yes, page 17. Page 17.
Yes.
Page 17, your lordship sees
That chart.
the chart, my lord.
No, but what is the how do you bring this chart?
My lord, we bought this chart on.
Mr. Sharma, are you following the question?
Yes, my lord.
Specific averment
Yes.
that on 16th you are not allowed. Where is that? This is a chart which indicates that on 6th denied,
Yes.
on 16th conducted
Yes.
for Jiaul Pasa.
Yes.
On 16th denied by the petitioner as his DA was not permitted. Then 16th denied by the petitioner as his DA was not permitted. Now, thereafter, was this allowed? How do we know? Where are the
Averment is at page 11, paragraph 24.
yes?
That being aggrieved, the petitioner preferred another letter dated 6/1/2025 before the inquiry officer pleading for an extension to present the list of witnesses along with the defense assistant.
Mr. Sharma, not all this.
The second paragraph.
You see, you are doing very fine, but now you are going to confuse the court. But otherwise, you will not get the
Yes,
judgment today. I was almost ready to
Yes, madam.
dispose this petition. So you come to the point.
Yes, madam.
Where, because let us see the inquiry proceeding. Where in the inquiry proceeding you can demonstrate that you are not allowed cross-examination, which you've been urging before this court.
My lord, your lordship, the second paragraph at page 20, at page 11.
No, that is your averment. Where is the inquiry proceedings?
The inquiry, my lord, the inquiry report starts, yes, from page 82, my lord.
Page?
It starts at page 81 onwards. It is the findings of departmental inquiry.
81.
81.
Yes. This is the inquiry proceeding.
Yes, madam.
This is findings. But Mr. Fukan, you must be having the proceedings, no?
My lord, the inquiry report itself, my lord, contains the
Okay.
denial of cross-examination.
It is there.
Yes.
Admitted.
My lord, admitted.
Where? Which part?
My lord, this page number 82 onwards, all the PWs, my lord, first 85, my lord. Page
Yes.
85 down below.
Yes.
Charge officer was asked
He
like to
was asked if you would like to cross-examine and he agreed.
and availing the opportunity, charge officer cross-examine PW1.
So
Now
one is
to-
cross.
Now PW2, next page, down below. PW2,
Yes.
he declined.
The charge officer was given chance, if any, but he declined.
Yes.
Yes.
And next page, 87, PW3. Charge officer declined to cross-examine PW3 in the middle.
Three. Declined. Yes.
87.
87. Okay.
Now PW4 starts and phase 88, cross-examination, charge officer declined to
Declined.
cross-examine PW.
Where? You're going too fast now. Wait. On the top.
88.
Yes, I got it. On the top. Yes.
Then
Denied.
PW5 starts,
Where?
then down next 89, the
Yeah.
middle. The charge officer was given an opportunity to cross-examine the PWRA,
But he denied.
but he declined.
Yes.
On the same day, charge officer proposed name of two persons. Now, next pair, it is important. On 27/1/2025, that later, my lord. The charge officer was again given the opportunity to cross-examine the prosecuting witness. This time, he cross-examined the PW as
As
follows.
follows.
R.A. Chaudhary, charge officer, GP Khatonier, question.
So he's done.
Next, PW6, again, my lord, page 91. Charge officer was given the chance to adduce defense, but declined cross-examination.
For two, he declined or what?
For PW6, it starts from page 90, my lord.
Yes.
The middle portion PW6. Now 91
Declined.
declined.
Yes. Then
Then statement of Prashanta Burman, that deputy registrar presenting officer. So, my lord. So, my lord, all the PWs have been
who is this? Prakshanta?
Burman. He's the
He's
deputy.
the presenting officer.
My lord.
And this the charged office, statement of charged office.
And this date 27/1/2025, that was indicated in page 89 in the middle portion.
Yes.
That day, my lord, that
Which
letter,
date? 27, yes. on
27, 89. Charge officer was again
Yes,
given the opportunity.
you have got your opportunities.
No, my lord. Those.
Lord,
How can
misleading.
Yes.
we ignore the proceedings?
No, my lord. The proceedings are right. My lord, the indication of the facts which have been stated before this court, my lord, they're correct. But, my lord, the liberty which was granted to me was on 27th. These proceedings, these cross-examination, my lord, the option was given to me on 16th and 6th. On 6/1/20.
That's all right. On 27th, you have cross-examined.
No, on 27th, my lord, I was given the opportunity to cross-examine R.H. Chaudhary, which I've done.
Mr. Counsel,
Yes.
it appears that all the prosecuting witnesses
Yes, my lord.
either you have declined or you have cross-examined.
On separate dates, my lord.
Whatever,
My lord,
whatever be it, but you have done it. So no prejudice is caused to you.
my lord, if I may submit, my lord.
Is it not,
there's a
is
reason.
it uncommon in the trial court proceedings that a cross-examination
Absolutely not,
sometimes
my lord.
happen
I'm not
on
disputing
the
on
day?
that. I'm not disputing on that,
Sometimes
my
it
lord.
is continued in 2 dates.
Yes, my lord. My lord, that is not the not the issue here, my lord. What has happened is
This point, Mr. Sharma, I'm not
no, my lord. The
going to
petitioner,
accept this.
my lord, the petitioner wanted to avail the services of a defense
That
assistant.
High Court have already taken a call.
Yes. So when
that
the-
is also closed.
when the matter was pending before this honorable court for a very short while, my lord, not more than a week's time. At that point in time, those 2 dates elapsed.
Which 2 dates?
6/1/2025 and 16/1/2025. Where
6/1.
6/1/2025 and 16/1/2025.
And High Court's order came when?
27/1/2025.
27.
1/2025.
1.
7/2025.
Read the operating portion of this order 27/1/25.
Paragraph 20, my lord.
Just read it.
Yes, my lord. Exactly.
If not cross-examined or if declined, what was it?
No, my lord, it is at page
Just read it.
68. My lord, yes, my lord.
77.
Yes. 77. The above being said, in the event the petitioner has not been able to cross-examine the 3 witnesses on 16/1/2025, the IO should consider giving him an opportunity to cross-examine the witnesses in the departmental proceeding.
Now on 16/1/2025, how many witnesses were examined?
My lord, on 16.
Just give me the numbers. Huh?
Yes, my lord.
PW
1,
16/1/25.
3 and 4. 1, 2, 3.
PW
PW 3.
3,
PW 2.
2,
PW 4.
4,
PW 5.
all on 16.
All on 16. PW 5 was in fact 16 and 27. That is why I could conduct his cross-examination.
Okay, now what about 1?
1, my lord, it was done on 6/1.
Now what about 3, 2 and 4?
Yes.
PW 3, 2 and 4.
Yes.
Now these you have not done cross-examination.
No, my lord.
On 16th you had declined.
Declined, my lord. Because this matter,
Now where is that letter of yours?
my lord, yes.
Saying that since you have declined and
Yes.
as per this court's order now you give, because
Ma-
that letter doesn't speak of that.
78, my lord. 78.
No, that letter which we had already referred.
Yes, my lord.
Where do you say these things? Please read. I'm not turning, you read. I'm hearing.
Yes, yes.
Read.
In this regard, I beg to state that I could cross-examine only 2 prosecution witnesses, number 1 and 3, so and so, while I could not do the same for the other prosecution witnesses due to the non-consideration of my defense assistant being a legal practitioner. The issue being sub judice in WPC number so and so before the Honorable Guwahati High Court was finally disposed of by judgment and order dated 27/1/2025.
All right. So you have made your point there.
Yes, yes.
Yes. After this, these people should have been given a chance. Yes, Mr. Fukan, what happened to these people after 27th?
The order
Because
in the event, the opening line is
yes,
in the event petitioner has not been able to cross-examine.
yes, they have not.
Milord,
Because of DA, want of DA, he is not going. You see what is the operating portion of the High Court's order? Consider. What is the order? Please read it again, Mr. Sharma,
Yeah.
for the benefit of all of us.
Yes. That portion. Yes.
last 14.
The above being said, in the
Right.
event the petitioner has not been able to cross-examine the 3 witnesses on 16/1/2025, the IO should consider giving an opportunity to the petitioner.
Should consider giving an opportunity. Now, where is that the consideration? You see, the consideration has to be there. He may reject it, but where is that consideration? This application was filed. Where is the consideration? I don't see it in the inquiry proceedings.
Milord, since Milord that decline and other.
No, Mr. Fokan,
Milord,
you no need to justify that part.
Milord.
Specific query is post 27. Where is the consideration of the IO to the application made by the petitioner? He has filed a representation after the High Court's order.
Milord.
Yes.
Yes, Milord.
Now, how did you react? How did you act on that? You
Page
see,
89, Milord.
you see, you are not asked to give him.
No,
You are asked to consider.
Milord.
Now, where is that consideration? Where is that application of mind?
That page 89, Milord.
Yes, where?
In the middle, my lord.
Yes, on 27-1.
The charged officer was again given the opportunity to cross-examine the prosecuting witness.
Witness who? Witness number 5.
He examined the PW as follows.
No. This time he cross-examined the PW as follows. Cross-examination of PW so-and-so by charged officer.
Yes,
And
that's
another thing,
No, one second. PW, R.H. Chaudhary is PW number
5, my lord.
5.
and regarding other
PW 5.
witnesses,
One second.
no date has
One
been-
second. PW 5. Then what about the... Then it's only 5. Only 5. What about the other witnesses? What happened to the other witnesses?
My lord, the date is important, my lord.
Mr. Pukan, I have
He
understood.
denied on which date, my lord? The
That
inquiry
was
report.
prior to 27.
No, my lord, it is not given, my lord. The date has not been given.
No, we are...
Possibly 2-3
Mr.
days.
Mr. Fukan,
My
you are going to go in sequence, no? 1, 2, 3, 4, 5,
lord,
right?
my lord.
It is not going to be that 5 will be given first and after 5, number 2 and number 3 will be put in the box,
My lord.
right?
That will be in seriatim.
Correct.
but-
Now, if you see the charged cross-examination, the charged officer declined to cross-examine the PW4,
On which-
PW3.
On which date, my lord, it is not reflected.
No,
from
then
here.
it is whose fault? Whose fault?
No, my lord, the annexers will verify, my lord.
Where are the annexures?
My lord, they have not annexed, my lord.
Why? No, but it is clear from here.
My lord, page 81, the exhibits, my lord. My lord, the exhibits have not been annexed, my lord.
No, these are going in seriatim. Now, because the on 27, the date which you have been heavily relying upon appears at page 89.
My lord.
So whatever has happened prior to 27/1/25 is on top. On the face of this, it appears that his consideration has not been given. And it is only in respect of PW5.
I admit that.
And that is because PW's 5 was not over before 27.
Yes.
Specifically, there is an averment in the writ petition. Where have you answered? Where, to this writ petition, to this chart? Where, in your reply affidavit, where is that statement?
My lord,
Where is that statement in your reply affidavit, Mr. Pukan?
my lord, before that, my lord.
Now, I will come to all that, but
Page 19.
page
PW6.
17, paragraph 37. How have you responded this? Page 17, the chart. Yes, Mr. Sharma?
It is responded, my lord, at paragraph number 5 of the affidavit, my lord, which will probably be internal page 104.
Continuing page then.
Continuing.
Yes.
That regard to the statements made in paragraph number 37 is also one of them, my lord. While putting the petitioner to the strict proof thereof,
You are reading para 4.
para 5, my lord, 5.
That's 105.
Here, all right, ma'am.
Yes.
This deponent humbly begs to state that the inquiry report with the findings dated 13/2/2025 has been furnished to the Guwahati University Authority by the inquiry officer concerned, and thereafter by a letter dated 13/5/2025 as issued by the respondent registrar of the university, the writ petitioner has been asked to submit his response within 7 days, informing him inter alia that the inquiry report has been accepted by the Executive Council in its meeting held on 21/3/2025, and the report has been forwarded for his response. It is stated that afterwards, the aforesaid writ petitioner has submitted a letter dated 16/5/2025 requesting for additional 7 days time.
So nothing's there.
No, my lord. This aspect has not been subject to my senior friend's correction, my lord, not been touched.
It has not been touched.
Since, my lord, it's
Yeah,
it
they
should
are.
be by inquiry officer, my lord. We should not, technically, my lord, we should not delve upon that inquiry.
Mr. Fukan, it is not about that. You see, an allegation has been leveled. Now, all that needs to be clarified is has the inquiry officer given that opportunity or not? There is a clear judicial order of this court.
Milord.
That is the only issue.
But the affidavit.
Here- Now, the affidavit should have clarified. The chart is given at page 17.
Milord,
In response to paragraph 37, you don't even say a word. So these facts are admitted.
Milord,
It is admitted, that means that that PW3 16/1/2025 denied. Now, so after 16/1, where have you allowed that part is missing? Because in paragraph 17, it is clearly given that on 16, Jiaul was examined, Anjad was examined, Singharam was examined, and R.S. Chaudhary was examined. However, as far as Jiaur is concerned, cross-examination was done. In respect of Anjad and Singham, it was not done. And in respect of R.S. Chaudhary, it was not completed, and therefore it was started again on 27/1/2025. But in between, already that order from the High Court has come, and he has also filed an application on 27/1/2025, and accordingly on 27/1/25, you have already given him the chance which he has cross-examined. Very well. But what about the other two? What about PW3 and 4? That is not there.
Milord, PW6 has been Milord cross-examined.
That's all right. 3 and 4. 3 and 4, Mr. Pukan.
Milord,
In fact, my lord, if I may be permitted to impress upon one fact, my lord, not more than that, my lord, page 62. Page 62 is when the inquiry commenced. That was the first date.
but the representation did not indicate.
62.
Page 62, my lord. This was dated 6/1/2025. I prayed for 14 days time for the commencement of the inquiry. There's a reason, my lord, why I prayed for that, my lord. The reason being, the present communication, second paragraph, was made at drkhatoniar@gmail.com in the last hour of the last working day of the week. I have not been allotted sufficient time to prepare myself to appear before the inquiry officer on an early hour of the next working day. Therefore, considering above facts, I would like to request your honor to kindly give me a minimum of 14 working days to find out my defense assistant and to prepare a list of witnesses.
This was
That is fine.
rejected, no?
That is fine. No, this was no, my lord. In fact, what has happened? Page 64 is their response. Page 64 is their response on the same date.
6/1.
64, my lord. Page 64, annexure
Yes.
P. They've agreed, in part, my lord, not 14 days. They've agreed to extend the commencement of the proceeding by 7 days.
Hmm.
But on 6/1 itself, prosecution witness number 1 was already.
That's all right. You cross-examined.
No, I didn't.
One.
On 6/1, I did not, my lord. Birinci Das, I could not do. So that was the day when I prayed.
But then the High Court's order doesn't talk about 6/1. High Court's order only talks about 16.
16/1. Yes. But my lord, the conduct, the
16/1 is.
16/1 also.
Hmm.
But what has happened is, when they had given me an opportunity of having partly agreed to my prayer of extension of the commencement of the proceeding, on that day itself, my lord, one witness was examined by the authorities, and that attained finality. Now, assuming that I was not given the ability or the opportunity of cross-examining the other prosecution witnesses, they still are there. My lord, there was an order of this honorable court. There was no reply to my.
So sum up your arguments.
My lord, my lord, the conclusion was already derived at by the authorities, my lord, before the commencement of the proceeding. My submission is that, and the reason being, my lord, is because the inquiry officer was entrusted into looking into the entire ambit and the aspect of the departmental proceeding, my lord, including cross-examination and examination of the opponent, my lord, also belong to a certain cadre in the Assam police. That is one part of
Mr. Sharma,
Yes.
I think we will do it like this. Give me a small note
Yes, my lord.
where you indicate the the grounds of biasness against the inquiry office, number one.
Yes, madam.
Make that as number one
Yes,
issue,
madam. Yes, madam.
where you categorically give these incidents
Yeah.
about the inquiry officer coming from that color,
Yes.
where that
Yes.
criminal thing is going on and all that,
Yes.
whatever you want to say.
Yes.
And in bracket, you mention in which paragraph or which annexure you are relying.
Very, very well, madam.
All right. And then the second issue
Yes.
about the predetermined mind,
Yes.
which is also apparent from the inquiry officer's thing,
Yes.
as well as the disciplinary proceeding. These are the two issues broadly.
Yes, madam. Yes.
One is the biasness of the inquiry, the entire inquiry proceeding should go.
Yes, madam.
And if that goes, it has to start from the from the issue from that memorandum by giving you the entire witnesses and
Yes,
everything,
madam.
correct?
Yes, madam.
And indicate that witnesses also, that list.
A slight
Now-
change, modification of the list.
Yes,
madam.
but then the witnesses which were there, the added witnesses in that list,
Yes, madam.
you have cross-examined.
Badrul Islam, my lord. He's the last one who was added. I'll just. Badrul Islam was a newly added witness, whom I did not, my lord, cross-examine, my lord.
What is reflected? You declined or what?
No, I just apologize for this, my lord. This shouldn't have happened. Badrul Islam was the ex-second kind of it. কিমান আছে? Badrul Islam was there. আপোনাৰ প্ৰথম পেজতে আছে।
You are looking for the inquiry
Yes, my
proceeding.
lord.
What is his name?
Badrul Islam, my lord.
That is PW6, page
Yes.
90.
Yes. Page 90.
You
Badrul
declined.
Yes.
The charged officer declined to cross-examine. So then don't add
Yes,
that point because
yes.
it's of no use. You
Yes,
see,
yes.
no prejudice is caused
Yes,
to you
since I declined.
since you declined.
Yes.
Focus on the points,
Yes.
main points. Otherwise, you because your key points are these two only.
This one.
The biasness and the predetermined mind.
Yes,
For biasness, I think that inquiry officer coming from that background, couple of the fact that
Yes.
despite the High Court has given the has directed giving you opportunity for cross-examining,
Yes, madam.
you were not that opportunity was not given to you
No, madam.
on that.
Yeah.
And in the inquiry, it is mentioned.
Yes, my lord. That the recommendation of the punishment.
So on that, you see if there is an authority that if the inquiry officer acts as if he's the, and because the disciplinary authority is not a postmaster, it is not their duty to just
Yes.
forward it and accept whatever the inquiry officer have suggested.
Yes, madam.
There should have been a independent exercise of
Yes, madam.
mind.
Yes, madam.
But it appears that they have already accepted.
Yes, madam. Yes, madam.
I think Ramjan would cover, but
Yes.
nonetheless, on the
I'll-
inquiry officer,
I'll ask for them.
when they, indicate the punishment.
Yes.
Okay. Yes, Mr. Fukan.
Particularly regarding cross-examination of the witnesses, that aspect. If we not forget about those dates, ultimately in earlier litigation, the point was that he needs defense assistant. That was declined. In view of his necessity to engage a defense assistant, possibly he declined the cross-examination earlier. The picture remains same. Since in the earlier litigation, dishonorable court declined defense assistant. So when he earlier dates declined to cross-examine, so Milord in later dates, without any assistance of the DA, defense assistant Milord, he won't proceed, Milord.
He won't?
He won't proceed with
You assumed it.
Milord, since Milord he
The
doesn't-
inquiry officer assumed it. In short, what you want to say is that the inquiry officer assumed that since he did not proceed earlier because DA was not there, And since High Court have rejected his prayer for DA, he will no longer, he shall not be able to cross-examine.
No, my lord, since the page 89 is clear that he has been allowed to
Correct?
cross-examine. And he did not, my lord, specify.
He said remaining witnesses. In that
Remaining.
application of 27, Mr. Sharma, just read that
Yes.
again.
Yes, my lord.
In the event. Just read it again.
Yes, my lord. Page 78.
I think remaining witnesses.
Meaning word is not there,
I
my lord.
think it is there. Just let us see.
Page 77.
Yes, my lord.
Page 77.
Yes.
Hmm.
Page 78.
Yes, read,
78,
read.
79.
77,
That
books order.
that above being said, in the event the petitioner has not been able to cross-examine the three witnesses
Three witnesses.
on 16-1.
Yes, those three witnesses, 3, 2 and 4. 3, 2 and 4, right?
So, my lord, since my lord exhibits are not here, my lord. So, my lord, to that.
Your
that-
records are here. I don't have to go with you have filed your reply. What else? Nothing is required. You have already filed your affidavit.
My lord,
The matter is taken up for final hearing. What more you need? No. Anything more?
out of three witnesses, my lord, this
Anything
PW
more?
my lord, regarding.
Number one, this point, I have heard you, I've noted.
my lord,
You are saying that it has been done and he has not, it will have been of no consequence, therefore no prejudice. This is what, in short, you are saying.
my lord, that SK Sharma's case, my lord,
Very well.
I'll rely
Very well. According to you, no prejudice.
be on the touchstone of prejudice. my lord.
Very well. Next.
My lord, next, my lord, regarding that recommendation aspect, my lord, Supreme Court clearly states, my lord,
Hmm.
in RG Teredesa and another case, my lord,
Hmm.
only one.
That the inquiry officer can recommend.
my lord,
What is it? Read.
para 5, my lord.
लिखी लो.
State of Gujarat
नाम
versus
Chief
RT
Convener लिखे लो. यार मैं तो इसकी केस की नहीं बना पाया.
1969 2 SCC
It was
157.
on list 194.
Para 5.
Yes, just read.
Para 5. In Union of India versus so and so, it has been observed that unless the statutory rules or the specific order under which an officer is appointed to hold an inquiry so requires, the inquiry officer need not make any recommendations as to the punishment which may be imposed on the delinquent officer in case the charges framed against him are held probe at the inquiry. If, however, it is important, if, however, the inquiry officer makes any recommendations, the said recommendations, like his findings on the merits, are intended merely to supply appropriate material for the consideration of the government. Neither the findings nor the recommendations are binding on the government.
This is paragraph.
Paragraph 5, my lord.
Paragraph 5 to mark করে দিও আর তাহলে লিখে দিও recommendation of inquiry officer not binding.
Then, my lord, I'll be very brief, my lord.
It's all right, you take your time.
My lord, now Ramzan Khan. My lord,
Which paragraph of Ramzan Khan do you want to rely?
3-4 paragraphs, my lord.
একটু ভাল প্রিন্ট এটা আহিল নেকি Ramzan?
Ramzan Khan and Karunakarn.
Yes, I already have Ramzan Khan. Which
Mila-
paragraph do you want to rely?
Paragraph 13, my lord, I have marked. Only 2-3 lines, my lord.
Paragraph 13.
13.
Yes.
Last page.
Yes.
5-9 last
Read.
line. In case his conclusions are kept away from the delinquent officer and the inquiry officer submits his conclusions with or without recommendation,
So this is also recommendation.
you know,
Okay.
proposes as punishment so far as the delinquent is concerned, you know, regarding those.
All
things.
right.
Now, para 15. We therefore come to conclusion, last line similar. We therefore come to conclusion that supply of a copy of the inquiry report along with recommendation, if any, in the matter of proposed punishment to be inflicted would be within the rules of natural justice and the delinquent would therefore
That is with the
the
recommendation. is the
42nd
inquiry.
amendment. Meaning.
That is different.
And now
There are
18.
two aspects involved. One is the inquiry officer himself recommending.
Yes.
And just can you, Mr. Sharma, just read that last part of the inquiry officer, whether it's a recommendation or what is it? Is it a
Recommendation.
positive assertion or it's a recommendation?
Madam.
What is the wording?
One conclusion and another one recommendation.
As the charges of
Clear heading.
misconduct against the charge.
Where is the heading, Mr. Fukan?
Heading.
Recommendation.
Conclusion.
Okay, fine.
then
Very well.
recommendation.
So, you see, Mr. Fukan, you are right that merely because an inquiry officer recommends doesn't mean that the inquiry office, inquiry report. Are you feeling hot? You want the
Little bit cold.
oh?
Document for my use.
So the merely because the inquiry officer recommends doesn't mean that he's biased or the disciplinary authority is bound to accept it. This is what you want to say. But every case has to be has to be seen in the context of the peculiarity, facts, and circumstances of each case, right? Now, here is a case where it appears that the inquiry officer is none but someone from that department where the criminal case is going on. He retired from that department.
No.
That is one of the allegations. But you have not said anything in your affidavit about that part. Number one. Number two, it appears that initially the witnesses where you had given him chance to examine, but he declined. I'm saying that I don't have DA. Now, later on, after the High Court has disposed of his DA application, rejected it, he again files a writ petition wherein the High Court says that give him opportunity if he was not allowed cross-examine. In the event he could not cross-examine on 16 so and so date, referring to those 3 PW witnesses. Now, admittedly, from the inquiry proceedings, it appears that on 16 so and so, these 3 persons were declined initially. Now, it appears that on 27th, after the High Court's order, an application was given. Now, after that application, it appears that only PW5 was cross-examined. And 6 is not those 3 people. 6 doesn't come under the 3 people
And
because
he did-
prior to 27 it was only 4 people
And
and 1 in the beginning.
may I interrupt?
Now
Did not object.
that
the
is
next
all right. His
episode.
objection, not objection is now immaterial because
Proceed,
there is
please.
an order of this High Court.
Miller.
There is an order of this court that
In
you
the event.
consider. He has given an application. The IO has not dealt with that issue and it appears that no opportunity for that. So this is one event which is going against you, which is weighing in the mind of the court to take a view that perhaps the inquiry officer was biased, and because he was biased, he went to the extent of saying that this is the punishment he is recommending. He could have avoided, but because of his biasness. And what does the disciplinary authority do? They immediately took a resolution, all right, we are accepting it, without even calling for the show cause. Then they show cause and they finally pass it. So if we cannot be, this court will have to scrutinize and see the entire chain of events, right? Correct. Now, when we look into the chain of events, it appears that perhaps the fairness may not have, it doesn't appear that the inquiry officer was fair. That is why the difficulty. So,
One crucial aspect, Miller, whether this honorable court will answer into in the midst of the inquiry proceeding and the decision taken by the authority concerned. Miller, normally after inquiry report, after 42nd amendment, it is given to the delinquent, which has been done in the instant case. Then he represents this biasness and other things, Miller. He will incorporate in that representation. That will be considered by the disciplinary authority then the aspect of penalty.
Yes, but here the disciplinary consider has already has
will-
already
I will come to
decided,
that.
accepted.
Not decided, my lord. I will come to
The
that.
resolution is there.
Resolution.
That page is, it is indicated accepted.
My lord, but the
The
dictionary,
accepted would, one would understand accepted is accepted.
it would be understood only on that word, my lord. If we go by the dictionary,
You don't need a resolution for, we don't have to go that far to open the dictionary to understand the
that-
meaning of accepted,
that
Mr. Mr. Furkan. Accepted in the context of that paper. Yes, which is that page?
page, my lord.
My lord, page 80, my lord.
Yes, Mr. Furkan, read page 80. The impute
the
order.
entire.
Yes, the entire order,
Milord.
please. This is to
That will
inform.
clarify whether we have
Yes,
accepted it.
yes,
or not.
yes.
My lord,
Please
I
read.
agree.
This is to inform you.
Dear sir, this is to inform you that I will read slowly. As per resolution number so and so of Executive Council, Guwahati University, adopted in its meeting held on 21/3/2025, the report of the inquiry officer in connection with the departmental proceedings drawn against you has been accepted by the council.
What?
Now,
No,
now,
Mr.
next
Furkan.
para, Milord.
We'll go to the next paragraph, but
Milord.
you pausing in the first paragraph.
Milord.
You tell me, what do you understand? Be fair. Mr. Furkan, be fair.
Normally accepted means, Milord.
Mr. Furkan, be fair. You're officer of the court.
Milord,
Pausing in the first paragraph, what would you understand?
it goes in favor of my
That
learning.
no, what
Friend's
you'll see,
interpretation.
you have to understand the entire first paragraph. What do you understand? That a resolution has been adopted.
to accept,
And what is this resolution?
to accept.
To accept the inquiry report submitted by the inquiry officer against the petitioner.
But that would,
Correct?
Milord.
This is what
First
you
para-
understand.
first para
Correct.
goes in-
Now we go to the
It
second
will be
paragraph.
in the context of the entire thing.
Now,
Second
yes,
para. Accordingly,
yes.
as per the state resolution of the Executive Council, the report of the inquiry officer is hereby forwarded to you for your response.
Very well.
So,
There's no doubt about it.
termination or major or minor penalty, nothing has been imposed.
No, that's okay. That's
If
okay.
accepted, then
See,
it should have been, Milord, imposed.
You see,
Immediately.
no,
But
Mr.
it
Mr.
has been
Furkan, what is the requirement of serving the second show cause notice? Is it for deciding what punishment to be given? Or is it an opportunity to the delinquent to give his reasons and give him an opportunity to convince you as why the findings of the inquiry report should not be accepted? Now here you have already accepted.
But
You have already accepted
but the
before giving him the opportunity. What remains, Mr. Furkan?
chronology of events.
Mr. Furkan, what remains?
Milord, since Milord said response, he has been.
That
Milord,
response is meaningless.
no,
it's
Milord, it is not
meaningless.
meaningless, Milord. Milord, since Milord, the
On
next-
this, you have you see, first part
My-
you may have a case,
Milord,
but as far as the second show cause notice is concerned, it is it is apparently clear that it is predetermined.
Milord, it's not an empty formality. The delinquent officer has been given the chance.
After you
Respond.
decided, after you
Then-
accepted.
Then what happened, Milord? The next Executive Council agenda. May I place that agenda? That will clarify the situation, Milord.
Yes.
Kindly take up my IA, Milord. The agenda has been given there. Affidavit in opposition. Affidavit in opposition. EC agenda
Page
127 to 130. 126 is the extension of time for submission of response. It is also important, Milord. He
That's all
has
right.
asked for extending the time.
You have
That has
given
been
him.
given.
Very well.
And now Annexure 3, very important, 127. What is in their mind, what is the meaning of acceptance? This agenda, next Executive Council meeting, earlier.
This is after his response.
No, Milo, response has not been given as yet. The next page kindly turn to 128, 129, my lord. Serial number 8.
Yes,
Serial number 8, 129, down below.
yes.
Consideration of inquiry report dated 13 to 2025. The consideration process is not complete as yet.
All right, noted.
Consideration of inquiry report dated 13 to 2025, as well as response thereto by Dr. Guru Prasad Khatoniar, academic registrar under suspension, note to be placed in the meeting. But till that day, Milord, the petitioner has not responded. And so, Milord, that agenda could not be proceeded further. So, Milord, if the acceptance word is, Milord, considered in the context of, Milord, entire chronology of events, it is not an empty formality. Sometimes, Milord, it happens, Milord. The administration, Milord, they
Mr.
use
Fukan,
the word.
Mr. Fukan, that let us not unnecessarily go into that, because you see, I understand what you're saying. Sometimes in a certain case, accepted may mean that you have received. But here, you don't need a resolution to receive the copy of the inquiry officer. Your document at page 80 is loud and clear. It says that a resolution has been adopted to accept the report submitted by the so and so against the petitioner. This would only mean that yes, you have accepted the findings. However, you have given him a chance to show. But the fact remains is that you have already accepted. You have already accepted before giving him that opportunity. Now, viewed thus, this court has to see whether that would would it be in violation of the principles of natural justice or not, whether a fair opportunity can be said to have been given to the petitioner or not, in order to show cause as why the findings of the inquiry officer ought not be accepted by the disciplinary proceedings.
In the
That is the question which ultimately has to be seen.
of February, that inquiry report has been placed before the authority concerned. And in the month of May, it has been accepted by the Executive Council to proceed further with the, Milord, the proceeding of departmental proceeding, Milord. It is one part that
Where it is said that to proceed further in that note, in that page 80, no? In page 80.
Page 80, madam.
Where is it said that the resolution is to proceed, is to now proceed? Where are all that?
this agenda is also clear, Milord. Next meeting.
That agenda is a next meeting agenda.
Very crucial, Milord. Since
That consideration, because that next agenda says consideration, doesn't mean that this court will ignore the page 80. Page 80 is very clear.
Milord,
Where is this resolution?
Milord,
Where is this resolution? Why is this resolution not on record?
I'll have to place the record, Milord.
Where are the records?
Milord,
Hey, Matok.
Milord, it may be treated as part hard.
Where are the records?
I'll place the record, Milord.
Tomorrow?
Milord, at least 1-2 days.
No, it's fair. I want to dictate when things are fresh.
Milord.
Otherwise, it becomes very difficult.
Tomorrow, Milord, but little bit.
And we have deadlines.
Milord, can it be on Thursday, Milord? At least Thursday, 2 days, Milord.
Thursday.
And
Mr. Sharma, you give me those.
Yes, madam. Yes, madam. Preferably
Note.
by tomorrow or day after, madam. As
If it's tomorrow, it will be.
Yes,
It is more
Yes, ma'am.
better.
Yes, ma'am. And Malo, just one more submission. My senior friend had submitted a case law.
Milord, I have not placed all the case laws, Milord. SK Sharma's, Milord, that only one para, Milord. May I place?
Yes, I'm not stopping.
Oh,
you.
Further, Milord, this constitution bench judgment, Milord, Corona Karan.
One second. Hold on a minute. Just 1 second, huh?
Milord.
নাই স্কেন কপিজ ন পৰহিয়ে পৰা মোৰ কালি গাটো বেয়া
Yes.
First, the petition then judgment.
Sorry, there was a bail order which required immediate mention. Yes.
Managing Director Asil versus B. Karunakarn case.
Where is that?
26 and 28. I only rely on two judgments.
Actually, this is ECI. Titya paisle niki etu?
I had furnished a hard copy.
Yes, that's right.
So,
And which were the paragraphs?
26 and 28.
No, no, Mr.
28 and
Sharma.
29, madam.
20,
8 and 29.
28 and 29, you are relying.
Yes, madam.
Mr. Sharma.
And
And you are relying
26, 28, also 29.
26, 28.
And 29.
Oh, the same.
Same word. Particularly 26 and 28.
Yes, read.
Milord. Para 26, Milord. Only some lines, Milord. It is para 26. It is difficult to say in advance to what extent the said findings, including the punishment, if any, recommended in the report, inquiry report, Milord, would influence the disciplinary authority while drawing its conclusions. The findings further might have been recorded without considering the relevant, it is important, Milord, the findings further might have been recorded without considering the relevant evidence on record or by misconstruing it or unsupported by it. If such a finding is to be one of the documents to be considered by the disciplinary authority, the principles of natural justice require that the employee should have a fair opportunity to meet, explain, and controvert it before he is condemned. It is negation of the tenets of justice and a denial of fair opportunity to the employee to consider the findings recorded by a third party, like the inquiry officer, without giving the employee an opportunity to reply to it. So the inquiry officer's report may have some lacuna, but the delinquent officer must have the right to respond. And that representation would be a response letter would be considered by the disciplinary.
That is on that point. That is different.
So, Milord,
See, Mr.
if
Fukan
there is-
cannot be relying in one or two lines and
Milord.
correct.
So, Milord,
Ultimately, the test is that there has to be a fair inquiry.
fair inquiry.
There are also decisions to the effect that if the disciplinary authority has already determined or already have accepted the findings of the inquiry officer, then perhaps that fairness is at large. Because you have already determined, you have accepted,
Then,
we are on that.
Milord,
Now, what you are showing is on a different context.
Milord, in spite of that, Milord, this entire documents, Milord, it will require some time, Milord, entire judgment. Anyway, Milord,
So you want to rely the entire judgment, yes, very well.
Lord,
You
since
can
that-
read, but ultimately, this is the ratio.
ratio,
The ratio is that there has to be a fair inquiry.
Milord. So, Milord,
Now, if an inquiry, if a disciplinary authority has already made up his mind and accepted it in a resolution,
Milord,
then that is why I said that you give me the resolution, place the records.
Milord, I will place those.
So unless and until the court sees how will the court apply its mind, whether you have accepted or not accepted, what has happened in the resolution?
Milord, I will place those.
You are
records.
by now you should have brought it on record because that is the issue involved.
Milord,
This decision has to be applied in the context of each case.
Milord, I won't take much time, Milord, only 6-7 lines, Milord. Next, para 28. The position in law can also be looked at from slightly different angle. Article 311(2) says that the employee shall be given a reasonable opportunity of being heard in respect of the charges against him. The findings on the charges given by a third person like the inquiry officer, particularly when they are not born out of the evidence or are arrived at by overlooking the evidence or misconstruing it, could themselves constitute new unwarranted imputations. We can skip the other sentences, Milord. The second stage follows the inquiry, so carried out, and it consists of the issuance of the notice to show cause against the proposed penalty and of considering the reply to the notice and deciding upon the penalty. What is dispensed with is the opportunity of making representation on the penalty proposed and not of opportunity of making representation on the report of the inquiry officer. The latter right was always there, but before the 42nd Amendment of the Constitution, the point of time at which it was to be exercised had stood deferred till the second stage, namely the stage of considering the penalty. Till that time, the conclusions that the disciplinary authority might have arrived at, both with regard to the guilt of the employee and the penalty to be imposed, were only tentative. All that has happened after 42nd Amendment is to advance the point of time at which the representation of the employee against the inquiry officer's report would be considered. Now the disciplinary authority has to consider the representation of the employee against the report before it arrives at its conclusion with regard
Before
to his
it arrives at its conclusion.
with regard to his guilt or innocence.
So
of the
that means
subject.
accepting the findings would mean what? Accepting the finding of the inquiry officer would mean what?
Regarding
Accepting
guilt-
the findings of the inquiry of accepting the inquiry report would mean that whatever the inquiry officer has found,
Milord.
whatever the inquiry officer has recommended,
Milord.
everything has been accepted.
Milord,
Mr. Fukan,
Milord.
see, you are not understanding. That is why repeatedly I am asking where is the resolution. You want, if you want to develop your case, you have to place the resolution. Otherwise, this case is against you. These decisions are of no consequence to you until and unless your facts are supporting you. That page 80 is against you.
Milord.
That page is 80 is absolutely against you. Now you want to develop it, you place the resolution.
Please.
This decision, the ratios are clear. You can bring 100 decisions, but in every decision, this is what has been mentioned.
Milord.
That this is the ratio of the apex court's decision. That before the inquiry, disciplinary authority make a mind, he has to give an opportunity. That is the ratio. The second, what is the use of giving a second show cause notice if the inquiry officer if the disciplinary authority has already made up his mind? That is that is the only thing which he has also argued.
That will, Milord, that will be revealed in the.
That is why I'm saying that you give it. These decisions are you are relying on the same paragraphs which the other side is also relying,
Milord.
because that is the law. There is no quarrel to the proposition that you are arguing, but your facts has to show that you have not taken a decision.
Milord,
That has to come up.
the last decision, Milord, I'll be relying that SK Sharma, Milord, that touchstone of prejudice, Milord. Since
Touchstone of prejudice in the context of that case, not in a case where you have accepted the inquiry officer and then given a show cause notice. Not on that.
Milord, even
it-
then, Milord, this SK Sharma.
You see, Mr. Counsel,
Milord,
these are well-known connotations.
Milord.
What is prejudice? How to show prejudice? Everything is there, but it has to fit in the context of each case.
Milord. Milord,
Unless and until it fits in the context of each case, these cases are of no consequence to you.
Milord, if the representation not considered by the disciplinary authority, Milord, as per SK Sharma, Milord, then Milord, Milord, again, Milord, go to the interdepartmental.
Heard Mr. P. Sharma, Learned Counsel, M. Sharma, Learned Counsel appearing for the petitioner. Also heard Mr. P.J. Fukan, Learned Counsel appearing for the
1, 2, and 3.
respondent numbers 1, 2, and 3 within bracket.
Got it.
Due to paucity of time, the hearing during the course of the hearing, it appears that the records pertaining to the
The resolution.
EC resolution.
the records pertaining to
The inquiry report, Milord. That will be.
Resolution number so and so, Milord, it's on page 80.
during the page 80, right, Mr. Sharma?
But R/EP dash 02 dash.
সেই ওপৰত hardly লেখা তাৰপিছত লেখা that Mr. P. Sharma so completed his arguments.
M. Sharma.
M. Sharma has completed his arguments. During hearing, where during the course of hearing Mr. P.J. Fukan and comparing for the respondent, it appears that the resolution number R stroke EC 03 stroke 2025 stroke 28 of the Executive Council, Guwahati University, wherein a resolution was adopted by the respondent in its meeting held on 21/3/2025, wherein the report of the inquiry officer in connection with the departmental proceedings drawn against the petitioner has been accepted, is not on record. Since the short question that falls for determination in the instant writ petition is whether, amongst others, is whether the second show cause notice issued after the resolution, after the said resolution, whereby the report of the inquiry officer is resolved to have been accepted, can be said to be vitiates the imposition of the impugned penalty of dismissal from service. Stop. Relist on such and such date, on which date the aforesaid record, the aforesaid resolution, the records containing the aforesaid resolution shall be placed before the court. Which date?
Milord, day after tomorrow, Milord.
On such and such date.
Milord, that dismissal termination, Milord, that has not been imposed as yet, Milord.
Oh,
Stay.
no,
Nothing
there is
has
a, there is a
been,
stay.
Milord, done, Milord.
Last fala ki dekhilo, based on which naki kola. No, এটার উপর a short question too. আচ্ছা মই edit করে দিম তোমাক. All right.
Will place that judgment of prejudice,
Mr.
Milord, on that,
Mr.
Milord, along with
Fukan,
record, Milord.
you
Milord,
please-
City of time, Milord.
No, you take your time. You please provide a list of the judgments along with the copies of the judgments you take back
Milord.
and indicate the paragraph numbers of the judgments you want to rely.
Milord.
Same goes to you, Mr. Sharma. You take back all these judgments, whatever you have handed over, give it back in a form of compilation along with the note. You want to give a note, you are also, if you want, you can give it.
My lord, my senior friend had relied on 1969 to SCC 157, where the inquiry officer can make a recommendation.
You reply to that. Your right to reply is there.
Yes, my lord. So I was just making on day after
That
tomorrow.
day,
My lord.
you give your right to, you've only argued.
Yes, my lord.
I have not heard your reply arguments. Hearing is not concluded, Mr. Sharma.
Yes, my lord.
Because to further proceed in the matter, I need to
Yes.
see that resolution,
True.
because everything depends on that
True,
resolution.
my lord.
Milord,
I'm grateful, my lord.
most obliged.
Actually, case laws can please take back the case laws and give it whatever judgment you both want to rely, give it in form of a compilation.
Yes, my lord.
Most obliged.
Or hearing in number 24.
Yes.
My lords, can we matter be taken up on Tuesday?
All right.
Yes, my lord.
As prayed for, relist on such and such date. 24. This is 24.
Item
Yes,
20.
item 24. Yes, ma'am.
As jointly prayed for by the learned council, and considering that the matter has been called at the fag end of the day, relist on such and such date. Tuesday,
No, no.
give it the date of Tuesday.
Yes,
16.
16.
25.
My lord, 25 to 29.
Same.
Same dates may not be preferred, my lord, because
25 to
29, 25 to 27, 25, 28 to 27 minutes. This
3.
Who is appearing for the other side?
Mr. Medhi was there. I had taken his consent, SK Medhi.
So as jointly prayed for, release, give another date.
I has taken his consent. We had agreed on October 30.
Hmm?
But Lordship can prepone, but he had said
That is too late.
Yes, yes, I know. But
No,
he-
before
he-
puja. On such and such did he agonish
Hearing that other-
considering the fact. Yes.
25th before it will be motion week, my lord, it will be declared a motion week.
Give a date. What date you had suggested?
He had suggested on 30, but they can prepone. It's
30,
up-
13.
30, up to
30th is too long. I don't reopening or did on such and such date.
16 is. just-
Yes, Mr. Gogol,
Yes,
you
yes,
enjoy your
yes,
puja and then you'll do the case.
Yes.
Yes.
That's 16, my lord. Well, I have similar prayers for item 31.
How many? You are now adjourning the entire list, Mr. Gogol.
My
You're coming one by one. Huh?
30, no, 31 and 33.
Huh? 30? Yes. Call the list. Call the list. Next matter.
Item 30.
30 to Matan.
Mr. Gogol, which was the other matter of yours? 31.
31 and 33. This I just need a sort of position.
Who is there in the other side in 31 and 33? Find out who is there in the other side and you inform the court master and give a date. 31 and 33 to Kuidu. Yes.
Here in this case, I should take you to page number 47, Your Honor. That is annexure number A.
You are Mr.
I am on behalf of Mr. NNB Chaudhary. He'll be coming in a while. I'll place.
He'll be coming in a while.
Yes.
Yes.
Your Honor,
Some accumulation, one Pathan matter is going on my, in the midst of Pathan matter, I am
on the way, Your Honor.
I am not saying.
What is the issue, Mr. Gogol?
Issue also regarding the acceptance of the PhD degree also. So
PhD.
PhD law. Some length of hearing is required also here also.
Your Honor, the thing was that.
What is the facts? Yes.
Yes, Your Honor. The thing is that, Your Honor, there
What is the
was
thing?
in page number 37, they constituted a screening committee, Your Honor. First, I would like you to take to the page number 37, Your Honor. 13th screening committee was formed who was headed by the VC of the Dibrugarh University for verification of the PhD degree, which was provided to me by Magad University, Your Honor.
I have not understood anything.
This screening committee was formed, Your Honor. This screening committee was formed to scrutinize my PhD degree, which I obtained in 2013 from Magad University, which is a UGC recognized university. Their query was that the entrance, I did not sit for any entrance exam, or I did not.
You have a PhD degree from what university?
Magad University.
Magad University. Now, according to them, this is not a recognized university.
No, Your Honor. According
What is
to them,
the issue? That's what I'm
according to
asking. What
them,
is the issue?
I did not sit for entrance exam and I did not give pre-course material.
You did not even sit for the entrance.
That
This
is
is-
not
this-
required, Your Honor.
This is not required.
Not
Our
required.
intention is that, Lordship, that particular PhD which was obtained by the petitioner were filed in the UGC regulation 2009.
That Magad.
Magad. Magad.
That is not
That is
recognized.
not permissible, Lordship.
That means that is not recognized.
That is not,
No, it is
university is
recognized. It
recognized.
is a very,
University is recognized, but the procedure which was adopted for the,
All right, on another date.
for giving the PhD degree is not.
Date of the detail. Acha, he is there. Yes, Mr. Chaudhary, come. I was told you'll be coming in a while. So I waited for a while and then I thought I will have it on another date. But since now you have
Yes,
come,
my lord.
yes.
My lord, what is the matter about, my lord? That the petitioner was appointed, my lord, in the year 1999, my lord. And my lord, in In Sontoli, my lord, college, my lord. Anchalik College, my lord. And my lord, he was working, my lord, in the year 2000. Working.
Just 1 second.
No, miss. Do this, last moment of the match. That's fine.
So
And-
he can continue, I will, he can continue, Lordship. I will, another matter is my brother will be here, Lordship.
Brother or friend?
Friend will be here, Lordship.
No, but Mr. Gogoi, I am not going to hear this in piecemeal manner. After Mr.
No,
Chaudhary
otherwise,
finishes,
after he finishes, we will start.
someone from the other
No,
side
we
has to
will start.
respond.
Otherwise, Lordship, my problem, today's problem is that, Lordship, in the two court, two Parhat matter is gone. Midst of a Parhat matter, I am outside the court, Lordship. That is the issue. Otherwise, no problem, Lordship.
When
Otherwise,
do you want it, Mr. Gogoi?
Lordship, any day, Lordship, today is some difficulty.
Thursday, I have already fixed a lot of matters.
And then my.
Next Tuesday, Mr.
As
Chaudhary?
per convenience of the master.
Next Tuesday? Have a look.
No, otherwise, if Lordship,
No, not piecemeal manner this court doesn't do. We have deadlines to meet also. We want to finish
I'm
off
ready to
matters.
do it, my lord. I have some.
Correct, that is why.
I have urgency. I am still working as tutor.
No, absolutely. Even the court would have gone.
no, I have no difficulty. He can continue, then Lordship, I will join him.
But Mr. Gogoi, today only. Because you are saying it, so that is why I'm asking. If you want, I can accommodate you all on next Tuesday. And if you want the case to be taken up right now, this court is ready.
If
So
Lordship.
please tell me what is to be done without further wasting judicial time.
Any day, Lordship. Not Tuesday, Thursday, Lordship.
Yes, Mr. Chaudhary?
Thursday, Lordship. Thursday.
Next Thursday.
Thursday, Lordship. Tuesday, so many.
As prayed for by.
Cannot be my lord, partners, my lord.
No, I have not heard, Mr. Chaudhary.
I have some urgency, my lord. Top
Thursday
of the list.
and due to considering the fag end of the day, the matter is.
11. 11.
Yes.
11.
How much, Lordship?
18.
18. Yes.
Yes, what is this case?
Your Lordship, the petitioner, which I represented before, he was been caught for some ganja. There was actually a misinformation. He is a RPF constable. He was just doing his duty, and he has just he was the first who apprehended those persons who was dealing those ganjas. Later on, from somewhere, the civil police got a tip off. They came and they apprehended the petitioner, and on the basis of that, he was subjected to face the disciplinary proceedings, and without giving him an opportunity of being heard.
So the disciplinary proceeding was based on some FIR.
Yes. So after that, what happened? And the disciplinary proceeding started, and without giving the petitioner an equal opportunity of being heard, and he was removed from the straight away removed from the service. The entire process we challenged.
Straight away removed from service means no
Without-
inquiry.
Yes, on the basis of only a preliminary inquiry, and without giving him an opportunity of being heard and to place his defense.
Is it
He-
correct, Mr.
Yes.
Chhatrapati?
Yeah,
Yes, taking over the first.
that is
Matter was remanded back. First order of removal was set aside.
yes, that was that. After that, we came before the court, we challenged the procedure, and the entire process was been set aside, and he was directed to reinstate first, and if the department feels so, then can continue the disciplinary proceedings again by suspending him. So that the order is at page 36. which was passed by this court,
Yes.
the first order. After that, the second reinstatement after this certified copy order was submitted and he was reinstated, which is at Annexure 6, page number 48.
Yes.
After that, he was again suspended, which is at Annexure 7, page 49. And after that, he was again given a show cause notice for this disciplinary proceedings. And a statement of imputation, everything was there. Memorandum, but then again, the memorandum was published by which Pavan Kumar, which is of an inspector rank, he was been
Inquiry
appointed as he was appointed as an inquiry officer, which is at Annexure 9, page number 57.
Since we are hearing the matter, we'll go through all these pages, but in nutshell, you just
Yes.
so that this court can at least appreciate
Yes, yes.
the issue.
I will just give a brief to this entire gist of the
Refer
story.
to the pages right now, but you'll have to take me through all the pages.
Yes, yes, yes. And after that, this Pavan Kumar got appointed and he was suspended by the ASC. ASC in short means Assistant Security Commissioner. And the inspector rank Pavan Kumar, he was the inquiry officer. Both these two persons conducted the disciplinary proceedings and he was again been removed from the service. And
This
after
time,
that,
in this inquiry, all opportunities given.
opportunity given, but there is a certain other contradictions. Even though the opportunity was given, but that went completely on vec. That completely went on vec because he was again being removed from the service. This was the first instant. Second
I'm
thing.
sorry, I have not followed you.
Okay. So
to just cut you short,
Yes.
after the de novo inquiry,
yes,
in which you have been given opportunity to cross-examine and also to produce your witnesses, and after which the inquiry officer must have submitted his report. That report was given to you, and then the punishment was given. Correct? Now this punishment is of removal, and that is what you have now challenging. Now
that is what we have challenged.
correct? Now what is the you prefer to be addressed as how?
There are
No,
two-
how would you prefer this court to address you?
She-
Mr. or Mrs. Okay. Now, Miss Barua,
Yes.
tell me one thing. What is the ground of attack?
There are 2-3 grounds.
Yes.
The first thing, after he was been removed from the service, the trial was going on in the criminal court. He was termed as acquittal. This was the first thing. The second thing, the evidences generally in the disciplinary proceedings, the inquiry means disciplinary inquiry means towards the force personnel, that how he vitiated, how he has brought some impactful to the goodwill of the force. That may be the ground. But here what happened, the evidences which was collected in the trial, that got same as identical.
Barua, you are now on merit.
Yes, no, that is what.
You will have to appreciate.
No, that is what I'm
the,
saying.
the limited jurisdiction
Yes.
that this court exercise in such matters.
Yes, no, that is what the Supreme Court also says.
So now
That when the simultaneously both disciplinary proceedings and criminal proceedings can run, but both cannot be identical. And here it went on being identical.
you
the-
mean to say the charges are identical?
Yes,
What
charges,
about
evidences,
the witnesses.
even the witness who were there in the criminal case, they were also been a part of this.
Now, in the criminal case, you have been acquitted.
Acquitted.
But you see, there is one thin line of difference.
Yes,
The-
the
the-
benefit of doubt or
The standard of
is standard.
proof.
So in that case, Your Honor, there is one a recent judgment which yesterday at around 1 o'clock I was going through this judgment.
You are burning midnight oil.
Yes. So
Yes.
this judgment, it is based on the Southern Railway Officers Association.
Do you have the citation?
I don't have the citation. I downloaded it from the website. The case is the
Alright, then next Thursday you get hold of that copy.
yes.
Yes.
So
heard
this is the
MS,
first-
S.
another
Barwa, you get all the citations ready.
yes.
So and so. Also heard Mr. B. Chakrabarti, Learned Counsel appearing for so and so. relist on this Thursday? Thursday Department? Or next Thursday?
This Thursday will be fine. Thursday.
Next Thursday, Koida.
Next Thursday. Your lordship may just put it under the top of the list, because your lordship, what's the
Alright.
difficulty now?
Next.
What we face is
It's
so-
all right.